Good morning. Excuse me. Good morning, everyone. It's 9:30, so the inquiry's resumed. Just a couple of bits of housekeeping from me, and also check the advocates have got any housekeeping of their own. Firstly, can I confirm the site visit will be possible for Wednesday next week? Yeah. Yeah. Okay. So that will be 12 noon on Wednesday. Thank you. That allows me to make suitable arrangements.
Just to, before you move on, presumably that'll be gathering where the entrance is to the site proposed? Just make sure that people aren't waiting on different locations.
Yes, that's a very good point, Mr. Weeks. We will need to agree an area. I think somewhere where it's safe to park would be my priority. So perhaps I'll leave it for you and Mr. Holmes to agree where that should be. Or Mr. Holmes.
Thank you, sir. There is indeed a place to park. The farmer can open the gate to the field, and you can drive down. There's ample parking.
Okay, so is that the A5 access?
It is off the it's off the Lutterworth Road.
Oh, okay.
Yeah.
It's near that existing barn I questioned about, I think, on the opening day. Yeah, I know it. There's a sort of gravelish, sort of lay-by, sort of type access.
Yeah, it makes it easier. It is a little bit precarious otherwise.
Yes, and I have to think of not only my safety, but everyone else's. So, okay, thank you. We'll rendezvous there at 12 noon on Wednesday, so thank you for that. Secondly, I was going to say, I don't believe I've had a compliance statement from the council, and that would be quite useful, particularly if we run out of time today. Then I can probably rely on that.
So yes, of course. Mr. Green, who's been dealing with that, isn't here at the moment. But I do remember, I have a vague recollection of him saying that he was producing one some time ago. So I'm sure it's there or thereabouts, but we'll ensure that you have that as soon as possible.
Okay, that's helpful. And so we'll see where we go in terms of the day. If necessary, I'd rather deal with the conditions in writing, so I'd initially give some thoughts within the next couple of days in writing, and allow that to be sort of circulated and discussed. So my preference would be to try to fit in closings today if possible. But if not, we'll see where we go.
So yes, thank you very much for that. And I think we're both ready to go on closings when the time arrives. In respect of the conditions, there was a list that went around last night between the parties. That's added a few conditions that have cropped up throughout the course of the inquiry. I don't know which list it is that you're working on at the moment.
Well, I've been looking at the statement to common ground, and I'm mindful if that's changed, then realistically I'm not going to get a proper chance to look at that today. So I'm wondering if it wouldn't be more sensible for me to give any comments to both parties within a couple of days at the start of next week, and effectively we'll deal with that in a written format, and that might save time today as well.
So yes, I'm sure that's right, and we'll ensure that you've got a hard copy today, and we'll also send an electronic version via the case officer, but it might just be useful to have a quick chat between the parties before we do that.
Absolutely, and I'd as always, I'd very much encourage that. I will double check with my colleagues at Temple Key House, but at the moment I've not received confirmation that we've had the proving layout. So could I perhaps ask Mr. Holmes if that could be forwarded to PINS, and I think you probably got Helen Skinner's email address at PINS, and I think copied to her and the case officer.
That's fine, sir. I have. So Mr. Legg was sent the proof, I believe, on Tuesday, as soon as I'd received it, really, and we discussed it. So, yes, I will send it to both.
Okay, thank you. I'm just anxious that I've got that. Okay.
Yeah.
So that's it in terms of housekeeping from my point of view. I don't know if either Mr. Osman-Smith or Mr. Goatley have anything to add.
No, not particularly. I have to say I've only just had the draft conditions. It's not a matter of complaint or criticism at all. Doubtless we will look at those. If we're going to do that as a written exercise, then frankly that can be dealt with downstream. Learned Friend and I had a brief discussion about this yesterday in principle. I just haven't looked at these as yet, so it may be helpful purely in order to facilitate that dialogue if we do that prior to departure today.
Well, perhaps I'll leave that with you, and then, yeah, okay. Right, okay. Well, if there's nothing to add at the moment, then we'll begin with Mr. Stack and re-examination, Mr. Goatley. Thank you.
Thank you very much. Mr. Stack, good morning.
Good morning.
I trust you slept well.
I did. Yeah, it was a lonely evening, but yes, thank you.
I can obviously foretell the extent to which there is natural concern on the part of my learned friend and others as to the lonely time that you had last night, but there we are. Few matters arising, if we may, in respect of cross-examination yesterday. You were taken, you'll recall, to CDS 28, which was the draft DFT circular.
Yeah.
And you were there asked to look at paragraphs 72 and then onwards, and then particularly 81 and 82, dealing with identified need. Is that still the draft, or is that the draft circular, the most up-to-date document that we're dealing with here?
Sorry, what was the core document reference again?
CDS 28.
No, the more recent update is CDS 41.
Looking at CDS 41, so far as is relevant, because I think you were taken to, among other things, what was footnote 23 of paragraph 82. Where is that picked up in the extant circular?
So in CDS 41, in paragraph 81, it refers to footnote 26.
And then the previous text in respect of paragraph 80, does that reflect what otherwise was in the earlier draft circular, paragraphs 81 and 82 there?
Let me just go to that document, sorry. I'm just looking at both documents. So CDS 41 at paragraph 80 recognises that on certain parts of the SRN at certain times a shortage of parking facilities for HGVs. HGVs can make it difficult for drivers to find a safe place to stop. That is comparable to the earlier version.
Thank you. And perhaps not entirely helpfully, it talks about footnote 26. I think the way the document is set out, that's probably endnote 26. For those who are formatting nerds, perhaps like me.
That's correct. Footnote 26, if I can just go down to that.
Which is actually on PDF page 29 of 30.
And it says at footnote 26 that this will be informed by regular updates to the Department for Transport's National Lorry Parking Survey.
And is that essentially the same as what was in the earlier draft circular footnote 23?
It is, yes, sir.
Thank you very much. Now, you were then taken to CDS 6, if I can ask you to bring that up.
Yes.
And this is on page 9 of 111. And I think it's a terminology that's used both here and as we'll come to in due course, as far as is relevant in the earlier 2017 document.
Sorry, what page is that on the paper
Hard
version?
copy, the hard copy it's in the executive summary, so it's the 9th page of the executive summary, under the heading of off-site parking, parking in lay-bys, industrial retail parks,
Yes,
and
I've
then
got that.
appropriate parking.
Yep, I've had that, yep.
And then under appropriate parking, whether off-site parking is to be considered as inappropriate for overnight parking is undetermined. What do you understand by the term undetermined?
Undetermined, I would suggest, is that there is no view either way. So it is not to say that it is inappropriate, but it is also not to say that it isn't inappropriate.
Can we just compare that for a moment, please, if you have the NPPF available to you and the CD reference for that. S13, I am grateful, thank you very much.
Yes, I'm in S13.
Under paragraph 109, planning policies and decisions should recognise the importance of providing adequate overnight lorry parking facilities, taking into account any local shortages to reduce the risk of parking in locations that lack proper facilities or could cause a nuisance. So far as locations that lack proper facilities, have any been identified to you at industrial estates or lay-bys, or for that matter, retail parks, that would fall within the description that do have all of those facilities?
Yes. So in the PJA lorry parking capacity study, we looked at lay-bys and industrial estates which have no facilities, and there was parking evident in those locations.
Right. I beg your pardon. Did any of them have what might be described as any of those facilities?
No, they did not.
Right. If one looked at this issue about appropriateness or inappropriateness in context of NPPF paragraph 109, what does that say about the appropriateness or otherwise of off-site parking?
It would suggest that the off-site parking in lay-bys and industrial estates is wholly inappropriate.
Thank you very much. Are there any government, or for that matter, parliamentary documents that would suggest a different outcome to that question?
The parliamentary documents and the government documents make it clear, particularly in CD S11, paragraph 51, that parking in laybys or other inappropriate areas is not conducive to rest and recuperation, and they are deemed unsuitable locations.
Thank you very much. If we can look at the 2022 survey, it's page 20, or the PDF version 37 of 142. In terms of page 28 of that, it's the third paragraph, the pre-penultimate paragraph on that page, the one beginning off-site locations.
Yes.
Off-site locations being included as many lorry drivers still opt to park there. The reasons are being examined as part of the driver engagement, representing 35% of all vehicles observed. Whether off-site parking is to be considered as inappropriate for overnight parking is undetermined. However, there is a shortage of lorry drivers, and one reason for this is the negative public perception of the industry, as well as drivers feeling underpaid and undervalued. Providing drivers with safe parking facilities, with suitable washing and food facilities to enable them to have a pleasant overnight rest is important for improving driver welfare, perception and road safety. If safe parking locations with suitable washing and food amenities are the standard industry should aspire to in order to achieve these goals, then most laybys and industrial estates would fall woefully below this standard. When looking at the terms of that paragraph in context, what was said before in 2017 and that which is in the NPPF, what do you say should be the approach to the interpretation adopted by the inspector of paragraph 109 when looking at adequate overnight lorry parking facilities, taking into account local shortages to reduce the risk of parking in locations that lack proper facilities?
I think that the parking in laybys and other industrial estates where there are no facilities, as we said, is wholly inappropriate. I think drivers, while some may choose to park in those areas, many will choose to out of necessity because there is not enough space, or on the basis that they are, the facilities that are available simply aren't worth the money. I would suggest that they do not choose to sleep in their cab without a toilet or the ability to wash or with easy access to food. In fact, if you sort of drive around the area to the north of Rugby and in areas around Magna Park itself, you will see drivers parked up in their lorries with the curtains shut in their cabs. They will have their doors open on the back of their lorries. The reason they do that is to make it clear to anybody that any would-be thief that they have nothing on board for them to steal, and I think that fear of crime is important. But yes, I think that parking in those particular facilities is wholly inappropriate, and I think that is a view shared by the government in both their ministerial statement and in CDS 11.
Thank you very much. You were asked to look at the 2017 survey, CDS 6. And it was page 67 of 111. Which is in the hard copy, also 67. It was looking at the position in the East Midlands and the availability of capacity. There's 1550 vehicles park on site out of then a capacity of 2167. And it was suggested it was fair to anticipate that in those circumstances there was still a substantial proportion who were actually voting with their feet. They were still parking off site. You explained what the position was in terms of driver hours. Could you just reiterate what the driver hours are, i.e. where they're allowed, how long they're allowed to drive without relevant breaks, and what is their daily and weekly entitlements?
That's fine. So the rest requirements, drivers are required to take a 45-minute break for every 4.5 hours driving. So they are permitted to do 9 hours driving per day with that break. They are then required to have an uninterrupted 11 hours rest per 24 hours. That can, I believe, be reduced to 9 hours rest. I think it's 3 times every couple of weeks.
So sorry, Mr. Stack, that's 9 hours you can drive to.
9 hours in a day, so it's
day.
4.5 hours drive with a 45-minute break, and then another 4.5 hours drive.
Okay, yeah.
So 9 hours driving in total over the course of a day, and then an uninterrupted 11 hours rest per 24 hours.
Okay, thank you.
And that you thought could be reduced up to 3 times every couple of weeks?
Yes, the uninterrupted rest, I believe, yes.
Thank you very much. Now, turning to also the capacity-related issues, would that exercise of choice being exercised then, and to the extent now, we'll come to the 2022 survey in a moment, does that suggest that there is no further need, or the need has reduced over time?
No, I don't believe it does. The need is still there. Drivers have a legal requirement to have these breaks, and therefore that need remains and will continue to remain.
Thank you very much. Turning to the 2022 study, CD S15. Same issues with regard to cost, as we've already discussed. With regard to cost and facilities, are there facilities available to drivers in the East Midlands that would obviate the need for lay-by and industrial estate parking?
There are facilities within the East Midlands, yes.
And those facilities, in terms of volumes of slots available, how would that compare with the extent of, at the moment, identified excess capacity, which is the 1,191 that we've already identified?
The excess capacity of 1,191 in the West Midlands are...
East Midlands.
Sorry, the East Midlands. Yes, that is the number of vehicles that are parking over and above the on-site capacity.
If I can ask you to have a look, please, at Table 5.1. It's on page 65 of the PDF version, which is
Page 56.
56.
Yeah.
That table shows for the East Midlands the number of on-site facilities, the vehicles observed on site 2443, and the overall on-site capacity 2661, which is about 220 thereabouts. A difference there.
That's
Would that be
correct. Yeah, that's correct, yes.
The excess vehicles, the 1191, that is shown there, is that on the basis of 100% utilisation on site or some other figure?
That's based on 100% utilisation.
Your view, please, is that consistent with the approach to examining practical utilisation, practical capacity utilisation of on-site facilities?
No, it is not. The practical capacity, that's the capacity at which a lorry park can be considered to be full, is 85%.
You probably heard the exchanges with Mr. Weeks. Would you concur with him that the figure of 1191, and so far as is relevant, the figure of 458 for the West Midlands would both need to be uprated by 15% to give rise to the relevant figure?
Yes, I would agree with that.
Thank you very much. You were asked within document S6, sorry to move you between documents, but the two certainly were available for purposes of discussion. If I can ask you to go to page 65. And table 511. Do you have that?
I do have that, yes.
This was immediate response estimation of additional parking requirements by considering lorry parks currently equal to or above 85% capacity. And it was suggested to you that taking the East and West Midlands, the 87 plus 216 amounting to 303, and in comparison to the appeal proposal of 293 spaces, that on that basis, looking at practical capacity, the appeal proposal would effectively be meeting those 303 aggregate figures your view, please, as to whether or not, as was contended, that was a good point on behalf of Mr. Weeks for the purposes of indicating there was an absence of justification for any further spaces now.
Yes, that's fine. No, I would disagree with that approach. The immediate response calculation looked only at the number of HGVs parked at on-site facilities relative to their capacity. It did not consider the need to provide HGVs off-site. The practical need figure is the number of spaces needed with all on-site spaces operating at 85% capacity, 85% utilisation. That is still a critical level of utilisation. It really arises from a rebalancing exercise whereby the number of parked HGVs exceeding 85% utilisation of some sites is simply redistributed to those with spare capacity. I don't believe this is realistic. The immediate response calculation exercise to which Mr. Weeks relies upon is not in the 2022 National Survey of Lorry Parks. And I would suggest, and it is only a suggestion, that its absence is because it is not deemed suitable or necessary to address need. I think what's important to note is that the National Survey of Lorry Parks on page 44, paragraph 2, talks around, and in fact I think the terminology is important, and I'll just go to that now.
This is still within CDS 6?
Sorry, this is in CDS 15. This is the 2022 version.
I'm grateful.
So on page 44, so 44 of the hard copy, in paragraph 2, just underneath the table, it refers to the shortfall. So it states that the shortfall in on-site parking capacity, a comparison is made between the total on-site parking capacity and all vehicles observed at all on-site and off-site parking locations. So it is clear, therefore, that the shortfall in the 2022 survey relates not just to the on-site but also the off-site parking locations as well. The shortfall is then referred to as excess vehicles later on, and that is where the 2022 survey identifies the 1,191 in the East Midlands and 458 in the West Midlands. And as we've said, that does assume 100% capacity, whereas utilisation of 85% is the point at which a site is considered full.
So in terms of understanding that shortfall, what would you then say would be the shortfall that you would expect to be then identified?
It's my view that the shortfall relates to the excess vehicles, both on and off-site.
Thank you very much. You can put that away, I think, certainly for the moment. You were taken to CDS 11. The House of Commons Select Committee.
Yes, I have that.
And if you can kindly have available to you both that and also CD 29, S29, I beg your pardon. So far as CD S11 is concerned, and its recommendations, you've already taken us to those recommendations in your earlier evidence, and in particular, give me, paragraph 51.
Yes.
In context of CDS 29, which is the government's response to that, was there any dissension from government in terms of its response to that which is contained in paragraph 51?
No, there is not.
Thank you very much. Now I'm going to try and deal with this shortly by recalling what Leonard Trent asked, rather than by asking you to have both S15 and S6 available to you, because it required, you may recall, a little bit of a tabular explanation or exploration between the two of them. But essentially it was involving looking at tables, which was tab 4.4, table 4.4 of CD S15, and also looking at the terms of S6. And essentially indicating that there was a reduction in terms of off-site stops. Do you recall that?
I do recall that, yes.
In your view, that assessment and that exercise, does that indicate that there is a justification believing that drivers, lorry drivers, would be resistant to sites which contain the appropriate facilities, for which this site is an example?
No, I do not. And I think evident to that is the recent completion of the moto services at Junction 1, which is a high quality facility, and our study showed that that was actually at 126% capacity. My view is that if you provide the quality provision, then drivers will choose to use it.
There was a question relating to lorry parking, and in particular that comprised in the most recent 2022 application regarding a site at Magna Park, about lorry parking being embedded within Magna Park. Whilst you dealt with the 2022 application, your views, please, as to whether or not lorry parking is embedded in the Magna Park operation as currently presents itself and as proposed to be extended.
At present, there is no lorry parking at all within the Magna Park site. There is a consented scheme for 134 spaces within Magna Park North. As far as I can tell, that will not have adequate facilities for overnight lorry parking. There is no mention of toilets, showers, cafes, or the like, and therefore I can only assume that that would have a NSLP rating of no more than 1. the yet to be consented scheme at Mere Lane does offer better facilities, not in the order of those which are proposed at the appeal site, it has to be said. However, that identifies only 94 spaces for overnight lorries. Clearly, if you take 85% of that as the practical capacity, that goes down to 80, I believe.
Thank you very much indeed, Mr. Stack.
Thank you.
So,
Yeah, just a couple of things, Mr. Stack. Firstly, could you just talk me through what the inside of a lorry is like? Not the the trailer bit that accommodates all the storage, but just the driver's bit. Talk me through what's actually in that cab, if that's the right term.
Yes, sir, I'll do my best. So they do have, obviously the facilities vary, as you would expect, depending on the age of the lorry and the type of the lorry. But in essence, there is an area for them to sleep. There is obviously a curtain that they can draw around the windows, and you would see that if you see lorries parked up in laybys. Beyond that, there is not much in the way of facilities for drivers. Clearly, some might have their own power. They might have some way of plugging in a microwave or something like that for them to cook with. But it's very, very basic facilities, and certainly not conducive to what I would regard as a good night's sleep.
So the sleeping area, that's not the driver's
No,
chair?
no. There's usually
that's a horizontal...
Yes, there's usually a separate area, yeah.
Okay, right. So is that sort of typically above the seats, if I'm seeing it from the...
I don't know, to be quite honest with you. It's to the rear of the seats. Where exactly it is in the cab, I'm afraid I don't know.
Okay. Right, okay. Just in terms of the Eddie Stobart Hotel, I think you were asked, I think maybe made reference to in examination, the cost, and I didn't write it down. What's the cost of the hotel at the Eddie Stobart site?
I don't believe I've made reference to that, sir. And I don't think I have those figures to hand, unfortunately. But I can certainly find out for you.
Okay, thank you. Okay. Just in terms of the need to sort of stay overnight, so from what you said earlier today, a driver can effectively drive 9 hours a day before needing to stop, well, to sleep, whether it's overnight or during the day. I guess it's up to them. So, I mean, in terms of the drive time from the West Midlands, I think Mr. Holmes made reference to drive times. I think it's his paragraph 4.42. He's suggesting most locations in England, Scotland and Wales can be reached within a 4.5-hour drive time. So the need to sleep, is that more passing lorries that are passing through the West Midlands or East Midlands rather than lorries originating from the East Midlands?
There is there's certainly an element of that, sir. I think next to a logistics centre such as Magna Park, you do tend to get drivers arriving from other areas and stopping overnight before unloading in the morning, or indeed unloading in the evening and then staying over before continuing their journey. Having said that, yes, absolutely, there will be drivers sort of passing through the East and West Midlands.
Yeah, but I mean, presumably, if the drivers are allowed to drive for 9 hours, effectively any driver that's driving 3 hours and then stopping overnight, that's their choice, isn't it, rather than the sort of necessity as such.
There is an element of choice, yes, sir.
Yeah, okay. All right, okay. Just in terms of the lorries having their doors open, I mean, presumably that as you say, they're doing that to discourage fees effectively. So would those drivers be perceived, in their view, to be at risk if they're leaving the doors open?
Absolutely, I think that's the conclusion that we can draw from that. The reason they leave their doors open is simply to demonstrate to would-be thieves that there is nothing in the back of their lorry to steal. One of the reasons is that what they don't want is for thieves to damage the locks on the trailer,
Right.
or cut the side of the trailer just to find out that there's nothing in there. So it's that damage to their vehicle that they're seeking to prevent by demonstrating to would-be thieves that there is nothing inside the vehicle. But I think there is certainly a fear of crime within the HGV community, and I think NSLP 2022 and CDS 15, in the driver survey there, it states that 92% of drivers feel that HGV crime has actually increased in the last 5 years. That is a perception. However, the fear of crime, I think, is important.
Well, yes. I mean, we read that elsewhere in the framework in terms of some of the design characteristics. But okay. So, but has any surveys or research been done to indicate that those lorries that are going on a lay-by are empty? Because from what you've just said, there's almost implication if you've got full load, you wouldn't be parking along the A5.
I don't think there's any studies, certainly that I've seen, to indicate that. I think if you do drive around the area, you will see some lorries with the doors open, and you will see some lorries with the doors closed. Clearly, that's not to state that every lorry that's closed is empty, but I think there's a mix. I think it depends on the individual circumstances at the time and whether drivers can find a spot in a secure facility or not.
You may or may not be able to answer this because it's probably quite detailed and intrinsic, but when the drivers plan their route, what are they effectively doing? Are they going on the internet to plug in Eddie Stobart's site or Corley and then seeing, same as if I was booking a hotel, do they do it in the same way, or do they rely on social media or other aspects?
In truth, so there's probably a variety of ways. There are apps available now which drivers can use, which will give an indication of where space is available at these sites. The main reason, obviously, is because there is a lack of space, to ensure that they don't have to divert considerable distance only to find that there is no space available for them. And that's particularly important in the context of their driving hours, which are legal requirements, and they wouldn't obviously want to leave it to a point where they might exceed those.
Yeah. Okay, that's all my questions.
Thank you.
Mr. Stack. So you can stand down now. Thank you.
Thank you very much.
So I think probably it's opportune to have a very short break now. Would 15 minutes suffice? Yeah, so, okay, we'll adjourn till 10:35 then. Thank you.
Seth, thank you. I
Yeah.
do have the SIL compliance schedule for you here, so
Oh, well done.
I'll give that to you now.
Okay.
I've also got a copy of the latest conditions, but my understanding is you'd rather that we just dealt with that, came up with a final version and sent that to you.
I'd rather see the final version rather than, and
That's fine.
thank you, Mr. Green, for the SIL compliance statement.
Thank
So
you.
I won't get a chance to look at that today, but
Yeah.
if that, again, could be forwarded to the Inspectorate, that would be very helpful.
Thank you.
Yeah, thank you. Okay, thank you.
Sorry, sir.
Yeah, sorry about that. Okay, so it's just gone 10:35, so the inquiry's resumed. So, Mr. Goatley.
So thank you very much. Mr. Holmes, I see you've taken up station in the witness table. If I can introduce you to the inquiry, you're Lawrence Timothy Holmes. You're a planning director at Lichfields Planning and Development Consultancy in their Birmingham office.
That's correct.
Prior to joining Lichfields in March 2019, you were an associate at Avison Young, formerly GVA in Birmingham, and a principal planner at DPP in London.
That is correct.
And you became a member of the RTPI in 2010. You hold a Master of Town and Country Planning degree, first class from the University of Manchester in 2006.
That is correct.
You have some 16 years practice, advising a range of public and private sector clients, both in the Midlands and nationally, and also encompassing a whole range of functions, development management, policy, amenity design, land use, visual, etc., as set out in your paragraph 1.5. A number of your projects, you tell us, have been greenfield, including providing both advice and evidence on sites of strategic scale and importance. And you set out the background of your dealings in respect of this matter. Your ability to act is set out in paragraphs 1.8 through to 1.12, and you provide a declaration as to the evidence that you provide being true and given in accordance with your professional institution, paragraph 113. And I take it you confirm that the opinions expressed are your true and professional opinions.
I can confirm.
Thank you very much. Mr. Holmes, you have the benefit in that coming here as what I think will be the last witness, we hope, that you, much of the detail has already been canvassed by the other witnesses. So I'm not proposing to deal with your evidence in chief in minute detail, but I do need to pick up a number of items, and the particular documents that I will ask you, if you may, have available are your main proof of evidence, the rebuttal proof of Mr. Weeks, and also the proving plan, which is, I think, ID 6, I think it is. ID 5, I beg your pardon. The proving example layout that we were talking about yesterday and the day before.
Yes.
Thank you very much. Now, as far as the appeal site, the reasons for refusal are concerned, those are known. So far as the planning policy context is concerned, this is from your paragraph 8 onwards. You set out the NPPF and the features which are relevant there. Can I, in passing, ask you to look at your paragraph 3.9 and following, so far as the aspects of paragraphs 81 and 83 of the framework, and whilst I'm sure the inspector will be wholly familiar as to its exact terminology, what you consider is the consequence of both of those for the purposes of the inspector's deliberation.
Yes, well, certainly the paragraph 81 of the framework recognises that decisions should help to create the conditions in which businesses can invest, expand and adapt. It's clear that significant weight should be placed on the need to support economic growth and productivity, taking into account both local business needs and wider opportunities for development. In terms of paragraph 83 of the framework, this goes on to state that decisions should recognise and address the specific locational requirements of different sectors. We also have reference to paragraphs 174 and 130 in the context of the reasons that were given for refusal of the application.
Thank you very much. You also, at paragraph 3.7, refer to paragraph 109 of the framework, again, which has been the subject of considerable discussion hitherto in context of this. what do you say that the inspector ought to do in context of paragraph 109?
And I think paragraph 109 is very clear. One of the things that stands out for me is that it doesn't just refer to parking places or parking spaces, it refers to facilities. So it requires all local authorities to take into account the needs of HGV parking within their areas, taking into account any local shortages, such that it reduces the risk of parking in locations that lack any proper facilities or could cause a nuisance. So I think when we cast our minds back to the findings that we have in the National Survey of Lorry Parking, that equates the shortfall to the excess vehicle figure in both the West Midlands and East Midlands, and we know therefore that the HGVs parking in those areas are not in off-site locations, are not being served by proper facilities to which paragraph 109 of the MPPF refers.
Thank you very much. As far as wording of the NPPF is concerned, just if I can take you to paragraph 109. And for, it says planning policies and decisions should recognise the importance of providing adequate lorry parking facilities, taking into account local shortages and reduce risk of parking in locations that lack proper facilities, etc. Just wanting to focus on where the NPPF is asking matters to be recognised for these purposes and comparing the use of languages. If I can take you back to paragraph 174, to which you've already referred. Now, the matter which I understand it was in play for this, as Mr. Weeks confirmed, it's 174B. A doesn't concern us here.
No.
But it's where planning policies and decisions should contribute to and enhance the natural and local environment by, and it's recognising the intrinsic character. Is anything in terms of the terminology there that gives an adjectival or qualitative view as to the importance or otherwise of that feature for the purposes of both decision making and plan making?
I don't believe that there is.
How does that, insofar as that may be compared and contrasted with the paragraph 109 formulation, which we've already looked at, and what, if anything, might the inspector make of that?
It makes reference to the economic and other benefits of best and most versatile agricultural land and woodland. I think the importance of paragraph 109 overrides. I think it's important to make provision for overnight lorry parking. It's very, very clear in that.
Right. So in terms of the utilisation of that word importance, do you attribute any function to that, any significance to that being incorporated in 109 and a similar formulation being absent from paragraph 174, for instance?
Yes, I would.
Thank you very much. Move, if we may, to development plan policies, paragraph 312 of your proof and following. I think we explain away the erroneous reference in the decision notice, and I think it's a matter of common agreement that the two policies to which the Council have identified reference is SD1 and NE3 of the local plan. In respect of those policies, your view, please, as to, on the basis of the material that's been provided both by Mr. Ingham and
Yes.
Pegasus on behalf of the appellant, your understanding as to whether there is conflict or accord, and the approach that may be taken both to the interpretation and application of those two policies?
Yes, the evidence that obviously was discussed in the roundtable discussion on Tuesday relating to landscape is specific to both the policies that are cited in the reason for refusal. If I go first to policy SDC1, we are of the opinion, and this is insofar as the scheme is relevant, and of course we're looking at parameters at the moment and not specific detail that would be dealt with by way of reserved matters. My view is, based on that evidence that we've put forward, that the maximum height of the proposed buildings would not conflict with the built-in natural features of the landscape in the immediate vicinity. The proposed buildings would be considerably lower in height than those at Magna Park. The footprint of the proposed buildings would be substantially smaller than most of the logistics buildings at Magna Park. The density of the proposed buildings would be considerably lower than those at Magna Park overall, whilst the density and massing of lorry parking would also be consistent with Magna Park. The proposed perimeter planting would be of a width comparable with that at Magna Park, and over time the substantial green infrastructure would largely contain development within the appeal site, that planting complementing existing blocks of woodland and green infrastructure in the immediate landscape. And I'd finish by saying that the proposed landscaping is substantial, robust and complementary to the surrounding landscape character, thus constituting an appropriate and proportionate design response to the proposed development. Now, in the context of policy NE3, from the evidence that we've presented through that roundtable discussion, we can say that it is evidenced through the original LVIA that we undertook early engagement and consultation with the relevant stakeholders at the Council on Landscape Mitigation. I would say that the report informed the initial landscaping strategy that was put forward. And of course, that was amended, as we know, during the course of the application in order to address the concerns that have been raised by the Warwickshire County Council landscape architect. It was certainly not an afterthought. There would be no greater than moderate adverse effect on the character of High Cross Plateau landscape character area as a whole, and that the effects on landscape character are limited and localised. The appeal site is not located within an area which exhibits strong tranquility due to the visual and audible presence of traffic on the A5. The proposed buildings would sit below the roof line of those in Magna Park when viewing the appeal site from the west, and therefore have no impact on the horizon to distance views across the plateau. The proposed development would relate well to existing topography and built form. Whilst there would be some loss of existing hedgerows, which we acknowledge within the site, the proposed mitigation in terms of green infrastructure would result in an overall net gain in landscape fabric. The visual effects would be limited to short sections of the A5 and the B4428 Lutterworth Road, and distant glimpses from public rights of way. The effects would not be significant, and the magnitude of those effects would be reduced by the proposed mitigation. By year 15, the only views of the internal features and structures of the proposed development would be at the entrance to the site on Lutterworth Road, and the tops of buildings glimpsed from a short section of the A5. There is indeed one tree that is subject to a tree preservation order, that is the English oak, that would be retained and protected within the site. That includes the root protection area. Whilst the proposed green infrastructure around the perimeter of the site would be complementary to the existing woodland belts, serving to extend these features upon maturity. The landscape has the capacity to accommodate the proposed development without significant adverse effects on the landscape character or visual amenity.
Thank you very much. So in respect of both of those policies, SDC1 and NE3, your view, please, will there be conflict or accord with them?
No, there would be no conflict with them, and they would wholly accord, in my view.
Now, in context of looking at those matters as a whole, as to accord or conflict. Your view, please, if the inspector were to take a view that in respect of one or either of them there was some level of conflict with one or either of them, and was to conclude in that instance that the development plan was being conflicted with for the purposes of approach, how would you say you should then go about things?
My view is that the tilted balance therefore applies, and I think obviously we're assisted by paragraph 11D of the MPPF on that. And the reason for that tilted balance applying is that the plan is silent on the provision of lorry parking, and indeed it provides no direction as to how lorry parking applications should be dealt with. We need to remember, of course, that the MPPF, or the previous iteration of the MPPF in 2019, included exactly the same paragraph, albeit it was paragraph 107. So whilst it's not a criticism of the council, for whatever reason, that has not found its way into the local plans. So there is no specific policy that is relevant in this regard. So 11D is engaged. There are no particular areas or assets of importance on this site for the purposes of footnote 7. And as we've heard through the evidence presented in terms of quantitative and qualitative need for the proposal, we consider that the benefits would significantly and demonstrably outweigh the harm to the any harm that may be found, although that is not our view.
Okay, we can just go back to 11D for a moment in terms of the terminology which is used there. Now, in terms of a previous iteration of the NPPF, yes, the word silent was utilised. Is the word silent a term used for the purposes of the formulation now?
It's not in the wording.
Right. So if we can just look at the wording within D, where there are no relevant to development plan policies, clearly we've seen the citation of NE3 and SDC1. Are those relevant policies for the purposes of considering matters here?
Not in terms of lorry parking. They make no provision for lorry parking.
Right. Policies most important for determining the application are out of date. Now, in fact, there's a footnote to that, footnote 8. And that indicates this includes, and then goes on to deal with for applications involving the provision of housing. Is this a housing situation?
No, it's not, and the paragraph 8 merely states it includes, so it is not exhaustive.
Thank you very much. When looking at the policies most important for determining the application, your view, please, what is the consequence, if any, of the absence of a policy in or policy reference in the terms of paragraph 109 of the NPPF?
That effectively the absence of that in the local plan would mean that the tilted balance is engaged in this instance.
Looking at the basket of policies upon which any decision would fall to be taken, your view, please, as to the consequence, if any, of the presence or absence of anything in the nature of paragraph 109.
Well, paragraph 109 again is very clear that local authorities, both in terms of decision making and policy making, should take into recognise the needs of the need to provide adequate overnight HGV parking within their areas, and clearly the plan is silent on that. So that is the key paragraph in the MPPF, which we should be led by in that tilted balance.
If we compare the NPPF with the terms of the development plan, is it, in your view, up to date as a policy matrix within the development plan insofar as it doesn't provide for something in the nature of paragraph 109?
No, the plan is not up to date. As I say, it's not consistent with policy paragraph 109. That was firmly in place by virtue of paragraph 107 at the time of the plan being prepared and adopted.
If you're able to assist on this, please do. If you're not, please say so. We know about the 2012 form of the NPPF. Prior to the February 2019 form of the NPPF, was there any other previous form of the NPPF that had been promulgated by government?
I'm not aware of that.
Okay,
Yeah.
thank you. Now, I'm going to go and look, please, at the questions relating to need insofar as they have not already been canvassed with Mr. Stack's evidence. Beyond Mr. Stack's evidence, what, if anything, do you say indicates there is a level of need for this development that would justify the grant of permission for it?
I think one of the key issues, this goes really to the heart of the government's recognition over the fragility of the HGV sector, and indeed retention is the need to ensure that there are adequate facilities to meet the needs of HGV drivers, to ensure retention, as we know from the Transport Select Committee report, its core document CDS11, that makes specific reference, indeed in the, I believe in the summary, to retention or lack of driver retention being directly linked to the lack of high quality HGV parking facilities. There is a groundswell of evidence within that report that comes from leading industry figures. So I can name a few, and these are bodies that represent the HGV drivers in large numbers. Elizabeth Dion, for example, who was the former head of policy at UK Logistics, has cited concerns over the lack of capacity, and this is a long-standing issue she's reported. She, of course, worked for the government as well within the Department of Transport, so is well versed in that. Adrian Jones, the National Officer for Transport at the Union Unite, has raised concerns on behalf of drivers around the inadequacy of HGV parking facilities. I believe he uses similar terminology, but effectively that drivers feel they're being treated as third-class citizens. He also makes the point that very often employers have not made adequate provision, and of course we see this on so many logistics sites, and I think it would be a fair observation to say that would apply to Magna Park so far. I mean, obviously we have two extant consents there, but neither have been implemented yet. We have the Women in Transport, also documented in the Select Committee report, who have made it very clear that their drivers are susceptible to crime. They lack secure facilities. The Minister for Roads, Buses and Places has raised similar issues. She is referenced as talking around the lack of capacity generally. Indeed, she provided a letter in respect of this application as well, which is in the core documents library. And similarly, the Road Haulage Association, on behalf of its members, has routinely raised concerns around the lack of parking provision and also the lack of good quality facilities. There is a letter from them in respect of this application as well in the core documents library. So I don't think we can underestimate just how important this scheme is, not just in terms of meeting a quantifiable parking need, but also what it does in terms of improving driver welfare and the ramifications of that, which are to retain drivers. It is therefore reflecting the government's sentiments on that, and is an entirely logical proposal in that regard, because of course, and as we've stressed throughout this process, and I think is demonstrably evident on the plans, this is intended to incentivise drivers by way of the comprehensive range of facilities provided. As we have made clear, it would comply with the label rating 5, NSLP rating 5, and indeed include one or two components in addition to that. That is ultimately to incentivise drivers to use the facility and really provide them with confidence that they will get best value for money, and of course discourage them from parking in lay-bys. They can have the confidence that they will be in fully secure parking with very accessible facilities nearby.
Thank you very much. Now, it's, I think, a matter of common consent that there's no policy requirement, among other things, to look to alternative sites in context of the assessment of this matter as set out in the Statement of Common Ground between the parties. Beyond that, looking at the extent of the need and the facilities which are proposed, can I ask you to take up your proof of evidence and the section dealing with the range of facilities? Now, I think both the quantitative and the qualitative need for facilities has already been extensively canvassed with Mr. Stack. In this guise, could I also ask you to have in mind as well the rebuttal proof of Mr. Weeks as well?
Sorry, is there a specific paragraph number within my proof to begin with?
Starting for you, in fact, it's your section of the public benefits, which is
Yes.
section 5.
Yes, I have that. Yeah.
Thank you very much. Beg your pardon. There are a number of components that are within the proposed development, and it's with a view to understanding, if I may, in respect of those components, how do those relate to the label or other ratings attributable to the site about which we've heard, the NSL or the label ratings, and which facilities are necessary for that, which facilities go beyond that?
Yes, indeed. In terms of the main facilities for achieving the level 5, security is obviously one of those. Now, in this instance, there will be full security for the purposes of the description given, so that will include 24-hour manned security, secure gate, security fencing, and indeed CCTV as well, to give drivers full confidence that their vehicles will be fully secure. It also will include a cafe element, which is required to achieve that level 5 rating. It will include overnight accommodation for those that wish to use it, which is specific to level 5 and indeed is replicated in the NSLP level 5 rating. There will also be the ability for vehicles to be for repairs to vehicles and general maintenance that will take place in the vehicle inspection unit and as an element of label 5. The retail provision as part of the facility is, on my understanding, also cited in the label 5 rating as well. So there is an optimal level of provision there. In terms of facilities that are not included within the label rating, effectively, as I understand it, that would be the PFS facility that we have shown and the e-charge facility. In addition to that, the creche as well, they would be excluded. If we just refer back to label 5 rating, we would of course be providing HGV refuel facilities, so that would also be included.
Thank you. Now, Mr. Weeks, in his rebuttal proof, paragraph 2.9, upbraids the appellant for the statement of case, paragraph 762, upon the issue of disaggregation.
Yes, I think as a point of clarity there, I refer to it in 2 separate sentences, and I appreciate that may have been misconstrued slightly. I believe that the reference I make is to the cafe by way of example for compliance with the label rating. When I refer to the elements not being able to be disaggregated, that is in a slightly different context, albeit the majority of the facilities on the site would be required to achieve that optimal level of rating.
Now, in respect of those ancillary or other items, we talked about the petrol filling station and also the creche as well.
Yes.
In respect to both of those items, where do those sit for the purposes of utility, for the purposes of the delivery of this particular development?
Yes, I mean, there is relevance for both. So in terms of the petrol filling station, I think one mustn't lose sight of the fact that whilst this facility is primarily geared for HGV drivers, there will be others in the logistics sector that will require refueling of smaller vehicles. So, for example, we know at Magna Park there are fleet drivers who will make deliveries via vans. They would benefit from this facility. They would also, of course, benefit from the facilities that go with that. So access to toilets and access to parking for periods of rest. So all of that is conveniently cited. The creche facility, whilst I acknowledge that at first sight it may seem a peculiarity for this particular proposal, when you begin to understand the context of why it's there, it becomes less peculiar. Effectively, this is driven by a need that the appellants recognise. At Magna Park, the appellant has had many years managing the estate at Magna Park, and indeed, obviously, during that time, became familiar with many staff and what their requirements were. I'm told, I can't quantify it exactly, but I'm told that there's a very high number of female staff there. And one of the overriding concerns that they had was that there was no creche facility. Now, I'm not aware of any such facility being provided at Magna Park. So this was really a response to that. It is a very small element of the scheme. It represents effectively around 6% of the total floor space. And I don't think it would make any tangible difference whether it was there or not in terms of the size of the facilities building. What I would also say, by way of it being labelled as an ancillary facility, is that we mustn't lose sight of the fact that this site in particular will employ over 100 people. Those figures are documented in the committee report. And in the spirit of providing a facility that is high quality, that's not only for HGV drivers, but also for its staff, that creche facility will of course be open to them as well to use. So it is a minor addition, but one that I feel is justified.
Thank you very much. I'm not going to go through all of the matters in Mr. Weeks's rebuttal proof, but you may recall there was an exchange with him on issue of spacing on the, between existing facilities which are non-HGV truck facilities. So far as the HGV component, is there any spacing issue that's involved here?
None whatsoever, and I think the architect has been very keen to stress.
No, spacing as in spacing between relevant developments on the SRN or otherwise. Spacing between developments.
No, I don't think there's any issue at all.
Thanks very much. Next, I'd like you to take up, if you would, ID 5, which is the proving layout example. Now, first of all, controlling plans in context of the planning application. Is this a controlling plan for the purposes of determination of the application?
No, it is not. It's purely illustrative.
Beyond the parameter plans, pursuant to the EIA exercise, are there any controlling plans?
No, there are not.
I think probably I should have asked, in context of the access plan, is that a controlling plan?
Yes, the access plan, yeah.
Thank you very much. My error in respect of that.
It's a detailed matter access. All other matters are reserved.
What do you say that the inspector should glean from this proving layout, including in circumstances where, for instance, there's no petrol filling station which is shown thereon?
The proving layout shows flexibility in accordance with the relevant parameter plans, and in particular the use classes and the height plans. There is flexibility there. We are showing a high number of parking spaces on this, and I would say that it's perfectly conceivable to reduce those standard parking spaces to ensure that the petrol filling station can be accommodated. And indeed, I concede the point, I think, that was made by Mr. Weeks around the delivery arrangements for the facility building. There would be sufficient space within that area of the site to accommodate a delivery bay, that type of arrangement.
Thank you very much. Weight, if we may, to attributable to the various facilities, and this, I think, starts with qualitative need, which the conclusions to that are set out at 5.13, and then you look at a series of other components to which weight is attributed. It would be fair to add or to observe that Mr. Weeks provided a different assessment of weighting in respect of those matters. Having had the opportunity to hear Mr. Weeks' evidence, do you come to any difference, or invite the inspector to come to any difference in respect of the attribution of weight to any of the matters that you've identified?
I think by virtue of the facilities that are being provided, the level of weight should be increased to very significant. That's the level that I attribute to it for qualitative need. That is a significant factor for the reasons I set out earlier on, that it goes to the heart of meeting drivers' welfare requirements, and indeed it is conducive to driver retention. This is an issue of national importance to the government. I don't think it can be divorced in this respect. As I've said, it's not merely a case of just looking at quantitative parking provision, albeit that is very important. And again, I attach very significant weight to that. I think Mr. Weeks' observations on the quantitative need are obviously based on what he felt was the level of need, which we believe is woefully short of what is actually required. So in actual fact, we know that this site is in what I call a geographical corridor of acute need that's reflected in both the critical levels of utilisation identified both by the NSLP and Mr. Stack's evidence, and of course the off-site parking that is occurring at a high level. So very significant weight needs to be attached to the ability to meet a proportion of that need, as I say, in terms of the qualitative components to really incentivise drivers to use this facility. The comprehensive range of facilities would do that. So again, that should attract very significant weight in the planning balance. That's where I differ from Mr. Weeks.
Thank you. In respect of the other services, the other components, any reason to review or alter any of your assessments of weight?
No, I don't think so at all. I would stand by those. So I think I refer to moderate weight for the ancillary services for non-HGV drivers. I think they're entirely appropriate for a truck stop facility. Indeed, they are replicated at other truck stops. There's nothing unusual there. Just in terms of attributed moderate weight, we've also acknowledged that there is a deficiency of EV charge points. Those, of course, would be available to van drivers as well as motorists. There is a need to increase that provision, particularly in the fullness of time, as we know that the government will be banning the sale of petrol and diesel cars by 2035. So the facility is well placed to meet that. So I would retain my view as to moderate weight. The other elements, the economic benefits of this, particularly looking at the logistics sector itself and ensuring that its drivers are retained, is an important consideration from a national perspective. In terms of the other facilities, I maintain the view the creche facility should be attributed moderate weight because it would serve a localised need, but it is a minor component of the scheme. The social infrastructure I attach limited weight to. It is acknowledged that the contribution for the local bus services that would be in the Section 106 is required to mitigate impact and provide for connectivity.
Thank you very much. You've otherwise given your conclusions, which I don't need you to revisit and read again now, Mr. Holmes. Mr. Holmes, is there anything else that you'd like to raise at this time?
I don't think there is at this point. Yeah, thank you.
Okay, thank you.
Thanks, Seb. Thank you, sir.
I think it might be slightly early to take a break, although I appreciate you may wish to break during cross-examination. I'll leave that up to you, but as long as we don't go too long in towards a lunch. But if you do need to break, I'll ask you, Miss Osman-Smith, just to give me a nod.
Okay, sir, thank you very much. And 1 o'clock being the time for lunch.
Well, ish, but
I
let's
mean,
not be Cinderella about it. So,
I'd hope to be finished long before that.
oh, right, okay.
In a similar vein to Mr. Goatley, most of the evidence has now been well ventilated before the inquiry, and the differences between the parties are well known. And Mr. Holmes, you arrive at a different view on the planning balance to Mr. Weeks, and the inspector's going to have to resolve that for himself. So, with that in mind, I've just got a few issues I need to pick up with you. The first is this. In your evidence in chief, you said the appellant has many years' experience of managing the estate at Magna Park. Just help me with this. Does your client have control over land at Magna Park?
Not as far as I'm aware.
So the many years of managing the estate at Magna Park, what does that mean?
They were employed at that site. They managed the facilities there. That's my understanding. Now,
Obviously, your evidence goes to the planning balance, planning policy, and weight to be given to the policy. And what you need to do as part of the planning balance as a planning witness is to understand all of the harms and benefits that go into that balance. The same exercise essentially carried out by Mr. Weeks. Now, it's right, isn't it, that you don't identify anywhere in your proof harm arising as a result of the appeal scheme?
I do not.
Do you accept that changing a greenfield site to one for built development is harm?
I think in the context of the policy it's concerned, that's any three, it's not relevant to the site in question. What we're looking at is the impact of the scheme in the surrounding area. So the harm would only be relevant in terms of the change to the landscape character and the visual impacts on that surrounding area.
Yes, exactly it. So we'll go back to my question and see if we can do this again. Do you accept that changing a greenfield site, undeveloped, to one for built development is harmful?
I would not necessarily accept that it was harmful.
So the answer is no, you don't accept that's a harm.
I don't accept that it's a harm, just on that side.
In landscape character terms, the effect of this scheme is to change the site from something that is undeveloped to one that will be predominantly hard standing with green infrastructure around the edges and all of the internal hedgerow removed. That is a harm to be weighed in the planning balance, isn't it?
It would be compensated for and indeed mitigated with additional planting.
That wasn't the question. To go back to the question, this proposal changes presently open, undeveloped, agricultural greenfield land, removes all of the internal hedgerows, replaces it predominantly with hard standing. That is a harm. That's a landscape character harm, isn't it?
It would be a harm to remove those elements. The policy is concerned with the wider surrounding area.
I'm asking you about the harm now. That's a harm, isn't it? It's a landscape character harm. That's what this scheme brings about.
That's not our view. It would be mitigated.
Mitigation's a different question because that's going to take some time to establish, isn't it? What you're not going to have at year zero is a fully fledged, mature mitigation.
No, I'd accept that.
Planting, right. So let's deal with this. Day one, this scheme goes in. open, undeveloped agricultural field, replaced mainly with hard standing, that is a landscape character harm, isn't it?
If you take that view in terms of the...
Now, I'm asking your
So-
view,
yeah.
and I want a really clear yes or no answer. It's not a difficult question.
I'll concede the point. Yeah.
Yeah, it's a harm. So that's a landscape character harm. And there's going to be adverse visual effects as well. We can take our day one example if you want, if that's easier for you to get your mind around. That's a visual harm.
At the beginning.
Yeah, you're diminishing the experience for receptors, people who are travelling around the area. Yes?
It depends on where they are seeing the site from, as we've presented in the evidence.
People are going to see this site from the local area.
Yes,
aren't
I
they?
would
They're going
accept
to
that.
see it from the A5, they're going to see it from
Yes.
Lutterworth Road. Even your own landscape and visual impact assessment identifies adverse views from further away on public rights of way.
Yeah.
Yes, they are harmful, or the impacts on those views are harmful.
Yeah.
Yeah. So we've established there at least some harm in respect of landscape character and visual impact. That is not something you tell us appears in your proof of evidence. It's not featured in your planning balance, has it?
I refer to the landscape considerations and the design considerations against the relevant policies.
Okay, make this really straightforward. Do you, in carrying out your planning balance, identify any landscape character or visual harm to which you attribute adverse weight?
I don't attribute adverse weight
No.
in the planning
So
balance.
that harm has not featured in your planning balance, has it?
There isn't specific reference.
Hasn't featured in your planning balance, has it?
No, I'm focused on the benefits of the proposal. It's for the inspector to take the view as to whether there is a harm or not.
It's for you as the planning witness to present the evidence on all the harms and benefits, isn't it?
Yes, I understand that. Yep.
Yeah, your job is to carry out a planning balance. That involves considering all of the harms and all of the benefits of a scheme. You've considered just one side of that balance. Just the benefits, yeah?
Yeah.
That's not a planning balance, is it?
It's not how I feel I've presented the evidence.
It's not a planning balance, is it?
I'll agree with you.
Take up your copy of the framework then, please, if you will. For those who don't have it as a standalone document, it's called document S13. And paragraph 109. You've been there in your examination in chief. Now, what we have here, as you've already read, is a policy that tells us planning policies and decisions should recognise the importance of providing adequate overnight lorry parking facilities, taking into account any local shortages to reduce the risk of parking in locations that lack proper facilities or could cause a nuisance. Proposals for new or expanded distribution centres should make provision for sufficient lorry parking to cater for those anticipated uses. So we're in the first part of that paragraph so far as the inspector's concerned in his decision taking, yes?
Yes.
That policy does not provide a presumption in favour of this type of development, does it?
No, it's not a presumption. It requires local authorities to recognise the importance of providing adequate overnight parking facilities.
Yeah, that's the highest the policy puts it. It's to recognise the importance of adequate overnight parking. It's essentially, it's a material consideration for the inspector to have regard to as part of his planning balance.
It is.
And in fact, it doesn't apply to parts or those elements of the scheme that are unrelated to the overnight parking proposal.
By that you mean the ancillary elements that we've referred to?
Yes.
PFS, yeah.
Yeah, the same justification can't apply to those as applies for overnight parking.
Yes.
Yeah, so this is not a policy that applies to the whole scheme.
As I've set out, those ancillary elements are considered to be ancillary to
Yeah.
this scheme, so they would serve some need that arises related to the logistics sector.
The creche wouldn't, would it?
Sorry.
The creche wouldn't.
I'll take that particular point is a minor element of the proposal. The primary purpose is a truck stop, which would be consistent with this policy, with this paragraph.
Yeah, but what we have here is a very large site, a number of different and disparate elements, 350 car parking spaces, for example. There are many elements of this scheme which are unrelated to the HGV parking element, correct?
I don't accept that view. I don't accept that at all. The majority of the facilities are relating to the scheme. Paragraph 109 refers to lorry parking facilities. It does not refer to spaces.
Let's be clear, overnight lorry parking facilities, that's what it's talking about.
Yes.
Yeah. So it's the overnight parking facilities with which the inspector has to concern himself when seeing how this policy applies. Yeah.
It is, but those facilities will be open late. So it's not right to imply that they would not form part of that overnight offer, in my view.
Well, again, let's be very clear with what we've got. The petrol filling station, that's not related to overnight lorry parking, is it?
No, I accept that point. That is a minor element of the proposal.
The creche is not related to overnight parking facilities, is it?
The creche and the petrol filling station, no.
No. 357 car parking spaces are not required for an overnight lorry parking facility, are they?
No, they're not. They're not for HGVs.
No. Vehicle inspection station. What relationship has that got to an overnight lorry parking facility?
They would be carrying out vehicle repairs.
Overnight?
I potentially. We haven't provided hours of operation for that. That would be down to the operator.
Have you had any operator interest in that?
I believe there is operator interest, but I can't comment further on that.
Right. Well, has that operator interest indicating that they would be working on vehicle inspections overnight?
I can't comment on that. I'm sorry.
Well, it would be unusual, wouldn't it?
I don't think it would be necessarily. It's entirely down to that operator, in the same way that you get retail facilities that would be open. We take Lim Truck Stop, for example. There are facilities there that are open 24 hours.
The intention for this site is that most of the lorry drivers who occupy it in those vast quantity of spaces are going to be sleeping in their cabs.
That might be an assumption. We don't know. Yes, there would be a.
Well, where else are they going to be sleeping, Mr.
No,
Hayes?
I agree. I would agree that yes, they would be, but that's not the only option.
They're not simultaneously going to be sleeping and having their vehicle inspected, are they?
Sorry?
They're not going to be simultaneously sleeping and having their vehicles inspected, are they?
That may be the case, but there will be other facilities there, such as the cafe, for example.
So is it intended that the cafe would be 24 hours?
That's for the operator to decide. It's not a matter for an outline application.
Well, we'll come back to that perhaps in due course. But let's deal with paragraph 109. First of all, you don't say that that is a policy that trumps other policy considerations within the development plan.
There are no relevant policies in the plan that deal with lorry parking facilities.
It's not the question.
So this is a material consideration.
It's a material consideration. The development plan obviously has a statutory importance that the National Planning Policy Framework doesn't. So you're right to identify it as the material consideration. And this material consideration in paragraph 109 does not trump what you've identified as the most important policies of the development plan in this case.
renders them out of date by virtue of the fact that the plan does not reference, it makes no provision, specific provision for lorry parking. And that is clear that planning policy, it's clear in the wording of paragraph 109 that planning policy should recognise the need to provide adequate overnight lorry parking facilities. There is no reference to that. There is no guidance as to how to determine lorry parking applications.
Okay, so I understand your approach. Paragraph 109 of the framework, in your view, does trump those policies of the development plan upon which this scheme was refused. Is that your approach? So I can be very clear.
My approach is that our scheme is consistent with those policies. And that includes the mitigation that's been put forward in terms of the landscaping. However, one can't escape the fact that the plan is silent on lorry parking facilities. So by virtue of that, the tilted balance should be applied.
Well, we're going to come and have a look at that very soon, in just a minute or two, because you know our case on that.
Yep.
I just want to deal with this. If the inspector were to find that there was a conflict with SDC1 and NE3, it's your case, is it, that paragraph 109 trumps the development plan policy in that case, or overrides it?
It would render it out of date.
Render it out of date. Well, the word that you used in examination in chief when speaking about paragraph 174 of the National Planning Policy Framework is that paragraph 109 overrides it. You used the word overrides.
Okay.
Now, as another policy within the National Planning Policy Framework, there can be no argument that paragraph 174B of the framework is out of date.
I would say that the policies in the plan are consistent with those paragraphs.
Yes, the policies in the plan are consistent with paragraph 174.
Yes.
Yes, of the framework, which is not out of date because it's also another expression of government policy in the government's latest up-to-date National Planning Policy Framework, correct?
Paragraph 11D references relevant policies, not just the most important policies being out of date.
Mr. Holmes, I said we'd finish by lunch, but we're not going to if you don't answer my question. So focus on what I'm asking you, provide an answer, and then qualify in any way that you must. Paragraph 174 of the framework is up to date.
Yes, in terms of it being consistent with the policy.
The policies of the development plan
Yes.
are consistent with the National Planning Policy Framework in respect
Yes.
of paragraph 174.
Yes.
In your evidence in chief, you said that paragraph 109 of the framework trumps, or overrides was the word you used, paragraph 174 of the framework.
No, that's not my intention.
That's not
I
your
apologise
intention.
if that's been misinterpreted.
Because there is, of course, as you identify, an importance of providing adequate overnight lorry parking facilities. There is also an importance in recognising the character and beauty of the countryside. Agreed?
Yes.
There is no national policy that goes further than paragraph 109 in setting out any quantitative or qualitative tests for parking facilities.
That's correct.
Okay, so 620 of your proof then next, please. 620. Let's deal with your tilted balance point. What you say at 620 is, notwithstanding my conclusion that the appeal proposal is demonstrably compliant with policies NE3 and SDC1 of the local plan, it is also the case that the silent stance of the development plan towards the provision of lorry parking facilities is inconsistent with the framework. The effect of this is that policies NE3 and SDC1, being those considered to be the most important for determining the appeal, are out of date such that limited weight can be attached to them. That's your evidence and you stand by it, yes?
Yes.
You don't anywhere in your proof refer to the basket of policies and that being out of date in respect of this case, do you?
I don't.
So let's take up paragraph 11D, for I think the third time in this inquiry, and take this stage by stage. So within paragraph 11, we've got two parts, right? We've got the first for plan making and the second for decision taking.
Yes.
And we're in the decision taking part.
Yes.
It's uncontroversial. So first of all, one has to make a decision about whether or not the plan is up to date or out of date, and whether the scheme accords with it.
Yes.
So that's C, because we know that the plan cannot be simultaneously out of date and up to date in respect of the same scheme. Now, you don't say this is a Part C case, because what you're not saying is that this is a scheme that's in accordance with an up-to-date development plan.
Yes.
Yeah, so that's why you say that we have to consider D. Now, you repeated in examination in chief that policy 109 of the framework, previously 107, was in place when the local plan was adopted.
Yes, it was.
Yeah. So it's right, isn't it, that on your approach, the local plan was out of date in respect of schemes such as this on the day it was adopted?
It doesn't make any reference, so it would be.
Yeah.
Yeah.
So a local plan out of date on the same day, the very same day it's adopted, that's the approach that you want this inspector to adopt.
As I say, it's silent on those provisions.
So the answer to my question is yes. That's the finding you're asking this inspector to make, that this is a local plan, relatively recently adopted, that was out of date on the same day it was adopted.
It simply doesn't make reference to those facilities. That's my point. And it renders those policies out of date.
So the answer to my question?
Yes.
Okay, let's look at 11D then. And we'll take this in stages. Tilted balance is engaged where there are no relevant development plan policies. Point 1, yes?
Yep.
We agree there are relevant development plan policies here. You've set them out. NE3 and SDC1 are what you describe as the most important policies.
Yes.
So there are relevant policies in respect of this application.
They don't deal with lorry parking facilities, so yes, they are important policies and of course they are what the scheme has been refused on.
Yeah, relevant and most important, I think, is fair, isn't it?
Yes.
Yeah. You haven't come to this inquiry and said, well, sir, goodness me, there's just no policies that apply in respect of this scheme at all. There's no part of the development plan against which you can assess this scheme. That's not your case.
No. Yes. Those policies are relevant in that regard.
Yeah. And not only that, but you tell the inspector in your proof of evidence, and you've repeated in examination in chief and cross-examination, that both are generally consistent with the MPPF.
Yes, that's fair.
And just to provide the reference for the inspector, in respect of SDC1, that's paragraph 4.10 of your proof. And it's 4.11 for NE3.
Yeah.
So we know then we have relevant development plan policies that are most important for determining the scheme and which are consistent with the MPPF.
Yes.
Yeah. And then we consider footnote 8, because that's what paragraph D tells us to do, and we know that that doesn't apply because this isn't a housing scheme.
That's correct.
So where all that gets you to is your point that the plan is out of date because it's silent on the issue of lorry parking. And what you say is that that silence on that policy renders policies concerned with it protecting and enhancing landscape and providing sustainable design are out of date.
They're consistent with the policy, with the MPPF. I think I've come to the view that they're up to date for that purpose.
Yeah.
Yeah.
But your point is essentially the silence of this plan, or the absence of a policy dealing specifically with lorry parking, renders policies concerned with protecting and enhancing landscape and providing for sustainable design as out of date.
Yes.
Yeah. So this silence that you rely on converts policies that are otherwise entirely consistent with the framework into policies which are out of date. That's your case.
If the inspector is inclined to take the view that there would be harm to the proposal, it's not our starting position with the case. Our case is that we are compliant with those policies.
Well, whether or not, forgive me, whether or not policies are out of date or not isn't reliant on whether there's harm.
No?
No. They're either up to date or they're out of date as a matter of planning judgment.
Yeah.
Yeah. And the inspector has to decide that first. That's where we began when we were looking at this part of paragraph 11, yes?
Yeah.
Yeah. So his finding on up-to-datedness or out-of-datedness doesn't rely on harm.
No.
There is no test of silence in the National Planning Policy Framework, and there hasn't been since 2018, has there?
No, that's correct.
I won't find any guidance or instruction anywhere that the absence of a policy specifically concerning lorry parking renders those most important, consistent policies out of date sufficient to trigger the tilted balance, will I?
No.
No. And the inspector doesn't get there through paragraph 11D either, does he?
I'm not sure.
Well, you've considered this and you've put this matter in your proof of evidence. You tell the inspector that the silence of the development plan on this matter leads to the engagement of the tilted balance. How, Mr. Holmes, do you get there?
As I've said, there is no relevant policy. It refers to, if we look at paragraph 11D, where there are no relevant development plan policies, or the policies which are most important for determining the application are out of date. We're talking about relevant policies being one that refers directly to lorry parking provision. There isn't anything in there.
Let's
From
go
my
back
point-
again to that first line. Where there are no relevant development plan policies. We've agreed there are relevant development plan policies, haven't we? You've looked at them in your proof of evidence. SDC 1 and E3, most important policies, they are
Yeah.
relevant policies.
Yep.
So the inspector doesn't get to the tilted balance that way, does he?
Yeah, okay, I'll accept, yeah.
Yeah, the tilted balance isn't engaged, is it?
In that context, no.
Not in that context, full stop, the tilted balance is not engaged in this case, is it?
I agree.
Now, as to whether or not the scheme complies or conflicts with the most important policies, that, of course, turns on the landscape evidence. That's
Yeah.
already been dealt with through the roundtable session. Something for the inspector to resolve.
Yeah.
There's just one matter on countryside location I'd like to pick up with you. Paragraph 415 of your proof of evidence. And if you've still got paragraph 109 of the framework to hand, that would be
Yeah.
a useful place to go as well. So what you say at 415 is, as I will deal with subsequently in my evidence, the proposed development by its very nature requires an open countryside location which is accessible for the strategic road network. I consider that in this instance policy GP2, by virtue of its deferring to national policy to determine whether the principle of development is acceptable, is permissive of the development proposed and consistent with the framework. And that's, I think, a matter of common ground as to policy GP2 between you and Mr. Weeks. But just help me with this point. When we look at paragraph 109 of the framework, and I want to just cast our eyes down to the second part of that policy, proposals for new or expanded distribution centres should make provision for sufficient lorry parking to cater for their anticipated
Sorry,
uses.
can you take me to the relevant paragraph number?
Yeah, paragraph 109 of the framework. We're looking at the second part of that.
In
now.
terms of my proof, sorry.
Oh, forgive me, 415.
Yeah,
It's on
thank you.
page 18.
Thank you. Yes, I've got that, yeah.
Yeah, and it's that part there that you said that this development requires an open countryside location.
Yes.
So paragraph 109 of the framework, we've dealt with the first bit, I just want to look to the second. Proposals for new or expanded distribution centres should make provision for sufficient lorry parking to cater for their anticipated uses.
Yes.
Now, there's an expectation that such facilities, that is overnight lorry parking facilities, will come forward as part of new or expanded distribution centres, for example, Magna Park, which benefits from a local plan allocation in this case. So it isn't the case that schemes such as this will always have to be located in open countryside locations.
I think my point on that is relates to Circular A1 2022 and paragraph 88 in particular for signage requirements requires that facilities of that nature should not be placed in residential areas. So in that context, it would require, in my view, an open countryside location.
In this case, or are you saying generally these sorts of facilities require open countryside locations?
I think generally it's a fair on that basis. In order to be signposted, they would require an open countryside location. I can't think of any relevant example where that's not occurred recently, and we're not aware of any previously developed sites that could accommodate that type of proposal on the strategic road network. I accept that there are extant consents at Magna Park.
Yeah, and indeed allocations elsewhere up and down the country. And of course, if something's allocated for this particular use, a storage, distribution and required to bring forward lorry parking with that, that's not going to be open countryside, is it? Maybe in character, but certainly not in designation.
No, I'd agree with that, yeah.
Yeah. So it isn't always necessary for facilities such as this to come forward in the open countryside, is it?
It's not always necessary, but it is, I believe, in this context, given where it is needed.
Because of the scheme you're proposing in its particular location.
To meet the need in the area, yes.
Well, the need could be met at Magna Park, but the fact of the matter is you've told us your clients don't have control over that land, so it's going to be delivered.
I disagree that the need can be met in its entirety at Magna Park, and we don't indeed make the case that the need per se can be met in its entirety by our proposal.
Yeah, and your alternative, forgive me.
The facility, the two consented schemes at Magna Park would be not of a sufficient scale to meet a significant amount of that need. So there is scope for this facility as well to contribute towards meeting the need, and we think it would do that more effectively by virtue of the facilities that will be provided.
2 points. There's a difference between us on how the need should be interpreted, and the inspector has the evidence on that, so I'm not going to go back there. But you haven't done a regional site search for alternative locations for this development across the West and East Midlands, have you?
No, and we were not required to in policy terms.
No, you're not required to, but if you're going to make a point that it's necessary to meet the need in these regions, which is what we're looking at, that the site has to be on open countryside, then you have to provide some evidence to back that up, and you haven't got it.
We're not aware, as I say, of any other site, and there is no requirement in policy terms to do that.
Yeah, but you didn't look.
I think we would have done, and the appellant would be, cognizant of the A5 corridor and their understanding of that. Magna Park is a major driver of the need in that area, so it was a logical place that one would look to provide this sort of facility. So my point around the open countryside location is that it is warranted here. There is no alternative.
No alternative that you've looked at, but we've already agreed that either you haven't looked regionally across the West and East Midlands, which is the need that you rely upon, or at least, sorry, forgive me, there's certainly no evidence before this inquiry as to that search being undertaken.
We've not looked elsewhere because this is where the need is most acute.
Quantitative need, I'm not going to go back over, I've done that with Mr. Stack. Qualitative is a matter to discuss with you.
Yep.
And the straightforward point is this, that better quality services cost money to people that want to use them?
There is a charge for the facility, yes.
Yeah. And we know that a significant proportion of drivers, nearly half, opt for free off-site parking, whether that's in lay-bys, industrial estates, or wherever it might be.
That is taken out of context with the other the other questions that were answered as part of that survey, as to the barriers to why they do not use charging facilities.
I'm not asking you about the barriers. The point is this: a significant proportion of drivers, nearly half,
Yes.
are parking for free off-site.
Yes, for their own reasons.
Yeah, for their own reasons, and
Yeah.
some of those preferences are going to be outside of the control of the appellant.
Potentially.
And so while it's a good thing to provide high-quality facilities, that's not necessarily going to attract drivers to abandon free parking if they are unwilling to pay in the first place. If money is the driver, it doesn't matter what quality
Well, I
facility
think-
you're providing.
Yeah, I would say value for money is the driver, and if they do not have confidence that a facility can provide secure parking, it's not providing, for example, cooked food, anything like that, the sort of facilities that they need, then it would not offer value for money. Thereby, they will be less inclined to use it.
Yeah, I mean, some drivers will choose, in those circumstances, free parking with absolutely no facilities whatsoever.
There may be a proportion that decide to do that.
Yeah. And for people who are just not prepared to pay at all for any level of parking, whether because their employer doesn't cover those expenses or because they would like to keep the expenses for other reasons, then the quality of facilities isn't necessarily going to attract those people onto site, is it?
Yes, there will be a certain element. I think we cannot lose sight of the fact that the government, and it's very clear in paragraph 109 of the MPPF, says that we need to be looking at providing proper facilities.
In respect of the East and West Midlands, when we look at the rating of the facilities that we've got,
Yes.
both in the 2017 and the 2022 studies, those are broadly consistent in terms of their ratings with the national average.
Sorry, the national average in terms of?
Let's turn up the documents. First
Yeah.
is called document S6. And probably worth getting S5 out as well.
S5?
At 15,
15, yeah.
forgive me. So S6 and S15
Yep.
are the two places we need to go. And for the S6 2017 study, it's pages 55 and 56 of 111.
Yes.
And for the 2022 study, it begins on page 32.
Yes, I have
So,
that.
so you see that essentially slightly different approach. In 2017, we've got 5 different categories, and we've had a new one introduced for 2022, which is where there are no facilities at all.
Yes.
And we can see set out in the 2017 study, so that's page 55, essentially by bars of colour what the facilities are, but perhaps more helpfully over the page you've got the numerical totals for the different regions, but also as well helpfully in England as a whole at the bottom. Do you see that?
Yes.
And we can see, looking at those, that broadly speaking, East and West Midlands are consistent with the national average for the distribution of facilities across those different facility ratings,
Yes.
in that the highest proportion is level 3, the smallest is level 5.
Yes. Yes. I agree.
Slight variations, it's fair just to pick up on when we get to 2022. Obviously, we know that more facilities have been provided. The number of on-site car parking spaces has gone up.
Yes.
And so when we look at 2022, we observe that we've got now a new category of 0.
Yes.
So we've got slightly more colours when we look on our bar chart, which is over on page 50.
On page 50.
50, yeah.
Yeah. Yes, I have that, yeah.
You have that. So you can see there, essentially the colour bar split again between the different regions, and there has been some change.
Yes.
And when you unfortunately, you have to go back and compare that to get the country as a whole. You have to go back into page 33 to look at the different distributions. But again, the point is what we've got here, East and West Midlands, is broadly comparable with the national picture. So it's 33, which is proportion of on-site parking facilities by rating, I think, for the... Yeah. Yeah, figure 3.3, I think, is all facilities. And then we compare figure 5 on page 50 for the West Midlands, East Midlands. So there's been some variation, but again, still broadly consistent with the national picture.
Yeah.
Agreed?
Yes, it's an average.
Yeah.
Yeah.
So there is not some unusual or unique issue in respect of these regions, that is the East and West Midlands, and the qualities of services offered compared to the national picture.
Well, the national picture is one of insufficient facilities being of the appropriate quality, which I think has gone to the heart of the government's response over driver retention and the need to improve driver welfare. So I accept the point that they're averages, but I don't think we should accept that as the status quo.
Well,
Just because the facilities in the East and West Midlands are ranked broadly in accordance with the national average, there is a deficiency, in my view, looking at those figures across the country. I think the government's been very clear in that, and I think that's evident in, as I've referred to earlier on, the Transport Select Committee report, for example.
When we look at level 3 and above, which is, forgive me, it's over 50% of the facilities nationally and
Yep.
in the East Midlands and West Midlands.
Mm-hmm.
We're talking about facilities that have as a minimum toilet, showers and a cafe,
Yes.
which this study regards as a medium level of facilities,
Yes.
basic amenities and wash facilities, going all the way up to level 5, of
Yes.
course, which then has the toilet, shower, cafe, lighting, security, fence accommodation and CCTV, which the study regards as high-end lorry parking facilities. Yeah.
Yes. Yeah.
And as we've said, what we have in the East and West Midlands is broadly consistent with that picture,
Mhm.
and over half achieve level 3 and above.
Yes.
Looking at the other facilities then, please. That's our next topic, the ancillary elements. 4.63 of your proof is where we need to go.
4.63.
It's on
Yes,
page
I have
30 of your proof, you have
that.
that,
Yeah,
yes?
I have that, thank you.
And what you say is there is that the appellant is not required to demonstrate the viability of any of the facilities intended to form part of the development.
Yes.
It is a material consideration for this inspector, though, isn't it, whether or not those facilities are deliverable?
Yes.
Because this is a scheme that is promoted as a whole, complete scheme, together with all of its different components.
Yes.
And you rely on those different components of the scheme as having positive weight in the planning balance.
Yes.
And so whether or not the scheme will deliver is, of course, an important matter for this inspector to have regard to as part of his planning balance.
Yes, the deliverability aspect, yes. I would
Yeah.
agree.
And
That's
whether,
reasonable.
forgive me, and whether the services are viable is part of that question as to whether or not they're deliverable.
I'd agree they're intrinsically linked, yes.
Yeah.
Yep.
And another question, in respect of the benefits of these schemes that the inspector will have to ask himself, is whether or not there's a need for those facilities.
Yes.
Because what this application seeks to do is develop open countryside
Yes.
for a new use.
Yes.
And so you need to justify, or you need to demonstrate that there's justification for the different facilities that you propose to put in this location.
Yes.
Now, the ancillary services that are intended to serve just car and van drivers rather than the overnight HGV parking cannot be justified by the need case that you've presented in respect of overnight parking, self-evidently.
Yeah, I would agree that the PFS and the creche facility wouldn't form part of that.
And all the land given over to 350 car parking spaces.
That particular area of the site, that figure of parking is not fixed.
No, it's not fixed, but it is a large proportion of the site. We've got nothing else indicated for it. And when we're looking at the amount of land take that you need for the different uses, you've got to justify what you're doing, because you're building on open countryside.
I would maintain the view that the majority of the site and its facilities would be given over to HGV facilities.
357 car parking spaces is nothing to do with
That's-
overnight parking, is it, for lorries?
That is a high number, but as a proportion of the site, when one looks at the plan, I don't accept that it is so significant to change the balance.
Now, a few more questions on the creche. The most obvious example of a facility that has nothing to do with overnight parking.
Yes.
In your proof of evidence at 484, just want to be clear because of an answer you gave in your examination in chief. First of all, you say this is not an element of the scheme that materially impacts upon the consideration of whether or not it's acceptable.
Yes.
In your evidence in chief, I think you gave the weight to that facility as moderate.
I did, yes.
Yeah, 523 of your proof. You say something different, and I'd like to know which one it is. Because there you say it's limited weight. Evidence in chief, you said moderate. We know.
Sorry, yes,
Yeah.
I did, yeah.
So it's limited, isn't it?
Sorry, I thought I had said limited. Yeah, that's correct.
You've provided no evidence of need for that facility, have you?
I would accept that as a fair point.
And it is a facility that's intended to be in the same building as a number of different uses, with hundreds, if not thousands, of people visiting every day.
It would form part of the facilities building as conceived on the illustrative master plan.
Yeah, well, it's the best we've got at the moment. So let's go with it. That facilities building is going to be visited by hundreds, if not thousands, of people every day.
Potentially.
And with, of course, childcare facilities, there's a need to ensure appropriate safeguarding and security.
Yes.
And that is a special challenge when it's situated essentially at a service station with those hundreds, if not thousands, of visitors coming along every day.
I'm not sure I understand the point. I don't think there's any difference between that and siting it anywhere else. Maintaining a secure facility would be applicable, in my mind, to any location, not just a truck stop facility in this case, or a motorway service area.
Yeah, the point is that security, whatever that looks like, is made more challenging when you're looking at a location visited by hundreds and thousands of people every day.
I'm sorry, I don't accept that point. I don't think it makes any difference. The unit will be secure. It doesn't matter how many people are visiting.
All right, well, the inspector can make his mind up about
Yes.
that. There's no outdoor amenity space for the children.
As we've discussed, there is flexibility within the site to do that. That is merely one configuration presented on that illustrative master plan.
We know from the information before this inquiry that there is going to be a significant noise impact arising from this scheme.
There will be some noise impact which can be mitigated, and the
Mitigated how?
it relates to the farmhouse dwelling,
Yes.
and that would be to the fabric of that building.
Yeah.
There is no other noise impact on any other receptor.
Right, so the noise impact is so significant that it has to be mitigated in respect of the farmhouse. Not an issue the council takes a point on at all. But if that relates to the fabric of the building, tell me this, how do you mitigate an outdoor space that children are playing in from noise impact?
I don't accept that you need to mitigate noise impact for children playing outside.
Right, so there's no need to consider whatsoever.
I think what we're concerned with are nighttime hours for residential dwellings. That's completely different.
Right, is there or is there not going to be hundreds of vehicles and HGVs going through this site every single day?
Yes, I mean, if, with optimal usage, that would be the expectation.
Yeah, is there or is there not a need to consider both noise and air quality impacts on children playing outside in this area?
I don't think there is a need particular to that sort of use. We're not talking about residential.
No, but we're talking about children playing outside.
Yes, and we've said
And we don't need to consider the noise and air quality impacts.
I believe our evidence is that
Is this turning into a new reason for refusal? Because if so, I think we need to have notice of that.
Not at all. It simply goes to the point about the
No.
outdoor play space
No, it
and whether
simply
or not
goes to
that
the
can be
point-
acceptably accommodated.
I accept the point of asking the question, but when the way that now this is developed, which is effectively saying you haven't considered this, haven't considered that, that is heading on the direction of a new reason for refusal. If that is to be pursued, that is a matter upon which I'm going to ask for an adjournment, and I'm going to ask for other matters to be dealt with in due course, if that is to be pursued in that way. Because what it is now heading to is a different view as to whether in principle this is a development which was refused purely for landscape-related reasons, is now being effectively morphed into a series of technical matters.
I don't believe it's going to be phrased like that.
No, not at all.
I'm
No.
sure that will be heeded and respected.
Yes, thank you very much. 2 final points on the crash. Do you know of any other service stations with crashes attached to them?
I'm not aware of any.
Have you had any operator interest in respect of the crash?
I'm sorry, I can't comment on that.
Right, so
That's not to say there hasn't been.
nothing you're willing to provide?
I
To the
can't
inquiry.
provide that. I'm sorry.
No justification for the crash facility here, is there?
I appreciate the evidence is anecdotal. I would accept that point. However, it wouldn't be there if the appellant didn't feel there was a need for it. It is, as I set out in my evidence, it's a very minor component of the scheme. It would be completely secure.
The supermarket,
Yes,
400 square metres.
yes.
Not sure what proportion of that is front of the store and or back of store. As Mr. Weeks explained, that's well beyond the size of an ordinary convenience store like a Tesco Express. Tend to be around 280 square metres to avoid the Sunday trading restrictions.
I wouldn't agree that it's well beyond. Tesco Expresses, yes, they're typically around 280 as a net sales area. This particular store, the 400 metres, just for clarification, is a gross figure. So it includes storage, what we call backup space with that. Now, the figures aren't set. There isn't a condition that limits the amount of net sales floor space. I would work on a ratio of 80-20. I think that's realistic for a shop of that sort of size. Yes, you know, as a proxy, I'd say it's not too dissimilar if we're going to visualise it, it's not too dissimilar to a Tesco Express or a Sainsbury's local in terms of size.
So my quick maths, with the assistance of a calculator,
Yeah.
gets me to 320 square metres on
Yes,
that.
that's correct,
As
yeah.
an 80-20. So that's a fair assumption. So the inspector will be able to understand the
Yeah.
size of the shop that we're looking at.
Yes.
And obviously, and it's called a supermarket, I think, in some of the documentation that we've had, that is a shop that is going to be stocking items that go well beyond the need of people parking overnight in their lorries.
No, I don't accept that point. With the truck stop facility, truck stop shops, very often there is a reasonable comparison goods element to that. So that may include, for example, clothing for HGV drivers. It can include cooking equipment, electrical items. So obviously they will take up a proportion of the net sales floor space. In addition to that, you may have newspapers, magazines, etc., as well as your more sort of standard convenience food offer. So I would say that there is a distinction between that and what you would typically find in a, if we want to use it as an example, a Tesco Express.
And we've also got 187 square metres in the petrol filling station that will presumably be providing other similar goods for people to buy.
Potentially.
Yeah. So now we're up to, what are we on? Your maths will be better than mine. 500 square metres worth of retail space.
Well, they'd be two separate fascias, I suppose we would call it. So, it wouldn't just be one shop. It would be a small, relatively small kiosk element that would serve primarily the needs of those drivers using the PFS, which I think is entirely logical, and then the larger shop facility, primarily geared, obviously, for HGV drivers.
Yeah. Straightforward point is that neither the petrol filling station nor the supermarket that's proposed are going to be sustained by overnight parking HGVs,
I
are they?
don't accept that view, and I think I put it in my evidence. That's entirely speculation on the council's part.
Well, help me with this. The petrol filling station, I would have thought that was obvious. That's not going to be sustained by HGV drivers.
Sorry,
it's
yes,
not intended for them.
No, sorry, yep, my mistake. Yep, the petrol filling station would be mainly obviously serving motorists and obviously van drivers as part of the logistics sector. The actual shop facility, which is the majority of the retail floor space, is intended to serve HGV drivers. Now, with regard to overnight parking facilities, there's every possibility that could be a 24-hour operation.
Right, so 24 hours, but, well, okay, I mean, let's assume that people are going to sleep at some point during that time. But what we have at peak parking use assumed by the appellant is 230 lorries parked overnight.
Yes.
Yeah, and obviously there are going to be other lorries coming through during the day,
Yes.
not of the same magnitude, I assume. You can tell me if I'm wrong on that, but lorries are generally occupied by one driver.
Yes.
Yeah. This is a large convenience store called a supermarket, bigger than a Tesco Express. It is fair, isn't it, as an assumption that that shop is not going to be sustained by lorry drivers alone?
I'm sorry, I disagree. It's not. It is not a large supermarket.
Okay, so you
As
agree
I-
with
as
that
I've-
description?
Sorry, as I've just set out, there will be flexibility for the operator to devote whatever proportion of floor space they want for non-convenience goods items. So that could mean, for example, 50% of that shop is given over to clothing for HGV drivers and other comparison goods.
The sorry, forgive me. Do you have any operator interest in respect of that retail element?
Again, I can't comment on that.
Nothing you
sorry.
can
Yeah.
provide. Okay.
Not at liberty to say.
There is, of course, as to the element of that shop that might be used by other passing custom people in cars and vans, there's no shortage of retail facilities in the locality, is there? You heard the evidence of Mr. Wheats, the supermarkets at Lutterworth, supermarkets at Rugby.
Whether they're open during daytime hours. They're not rest facilities.
No, I was talking about use by non-HGV lorry drivers.
Yes, there are other supermarkets. Yeah.
You haven't demonstrated that there's a need for a supermarket in this location other than related with the HGV use of the site.
We're not required to. But other, as I've said, this shop is primarily intended to serve HGV drivers.
The petrol filling station, the inspector will see close by to the site, most notably the Apple Green station just south of the site,
Yes.
that there are other existing petrol stations in the locality.
There are some further north on the A5.
So we've got the one south, we know that.
Yes.
Not sure how far away that is, but
Yeah.
a couple of minutes drive, essentially. And then I think it's probably when you get to Hinckley, if you stay on the A5, about 8 or
Yes.
9 miles north, yeah.
Yeah.
So again, no shortage of petrol stations for non-HGV users to take advantage of.
If it's just petrol that they need, yes, they would be served by those facilities. I don't know
Yeah.
if they are 24-hour facilities.
And in respect of Mr. Weeks's rebuttal, you've taken no issue on the factual information that he's presented as to the other facilities along the A5.
I obviously agree that they are what they are. There's petrol filling stations. I think there was a couple of instances where there are Starbucks, that sort of thing. But as I understand it, they are not designated rest stops. So yes, drivers may well be able to pull in and get petrol. As I say, I don't know if they're 24-hour operations, but they would not be able to take an indefinite period of rest at those facilities. Now you might argue that with the Starbucks, for example, there may be some car parking, but that would assume that they need to use that business. I wouldn't imagine the business would accept people just parking there who were not customers.
And on car parking, just finally, if we can have a look, core document N4.1. So core document N4.1, page 24. It's the revised transport assessment.
Yeah.
And if you have the latest proving layout to hand, just so we can understand this. Now, this latest proving layout, notwithstanding that its date is, I think, of the base plan September 2020, this was produced in response to Mr. Wheats's criticisms in his proof of evidence, yes?
It was produced to demonstrate that the site can accommodate the relevant facilities to which we've referred.
Yeah, but was this or was this not prompted by Mr. Wheats's evidence?
Well, yes, because he disputes that point.
Okay, so this
Yeah.
is the appellant's attempt to answer Mr. Weeks's concerns
Yeah.
in respect of the layout. Not sure which attempt this is, but it's certainly the second proving layout that we've had. There were master plans that preceded it.
Yeah, just to clarify on that, the preceding one just didn't contain that granular level of detail in terms of the car parking spaces marked out. I think the intention here was really to demonstrate, and admittedly it can be, slightly deceiving when you first look at a plan, think that there might not be enough space to accommodate the facilities. Just showing the parking spaces on there, for example, just gives you an idea of, I suppose, the sufficiency within that site to accommodate what is required comfortably.
Okay, well, 2 points about this plan and One of them involves core document N4.1.
Yeah.
First of all, in respect of the HGV fuel station, charge kiosk and truck wash.
Yeah.
On previous plans, we could see how those HGVs turned
Yeah.
towards the east of that section. That's obviously a concern that Mr. Weeks raised. That's still missing. At the moment, there's no demonstrated ability for HGVs to use that space in a practical way.
My understanding is that they will be able to manoeuvre within that space.
It's just not shown on the plan.
You mean in terms of tracking, or?
Yeah, in terms of tracking, because we've got tracking all over this plan, but fundamentally where it's missing is on the eastern edge of that part of the scheme.
Yes.
A point raised by Mr. Weeks, not remedied by this plan. 357 car parking spaces, and this is where we go to core document N4.1, page 24. We can see there that what was assessed as part of that revised transport assessment was 362 HGV parking spaces and 126 car parking spaces, 35 disabled spaces. You see that?
Sorry, can you refer me to?
Yeah, so it's
Specific.
page 24, and you'll
Yeah.
see the table 6.6, the estimated parking accumulation, and
Yes.
the paragraph below that. So
Yeah.
just read that. That
Uh,
was what was assessed as part of the transport assessment.
Below the table. Yeah.
Yeah.
Yeah. Yeah. 126 car parking spaces plus 35 disabled spaces.
Yeah.
Yeah.
And obviously what we have now is vastly in excess of that.
It is in excess. However, as I've said, I think the architect's intention was just to demonstrate what the site could accommodate. I concede the point around, and I think it's a reasonable point that Mr. Weeks made around the delivery aspects of that unit. So it would be entirely logical to assume that some of those spaces would be reduced to accommodate those sort of aspects.
But in light of those criticisms that you had 4 weeks before the inquiry opened, and having taken the opportunity to produce a new proving layout, this is your version of what can be done on site. That's what we see in inquiry document 5.
I mean that was done in relation to the criticisms that had emerged from Mr. Weeks.
Yeah.
Yeah.
It's your answer to them. Thank you. Those are my questions.
Thank you.
Okay, thank you. Mr. Goatley.
Sir, thank you very much. Mr. Weeks, you were taken to task with regard to questions relating to landscape matters. First of all, if you can take up the relevant policies from the development plan, NE3 SDC1, which are probably best found within the development plan itself, which I'm just going to find. S12, CDS12, if you've got that. Dealing first, if we may, with policy NE3, which is on PDF version I've got on page 81 of 167.
NE3 first.
Yep.
Yeah. Sorry, that was page.
I've got page 81 of 167 of the PDF.
Easy. Sorry, page 81.
Of the PDF, the actual pagination to the document itself is, it's page 76 of the document, original,
Is it 76?
but 81 of the PDF.
Sorry, yes, I do have that, yeah.
Yeah.
Thank you.
Deals with landscape protection and enhancement. New development which positively contributes to landscape character will be permitted. Development proposals will be required to demonstrate that and there are then a series of bullet points that are therein dealt with.
Yes.
If you can read through each of those bullet points, please, and then let us know when you've read through it.
Yes. Yes.
Thank you. In respect of those criteria, do any of those criteria utilise or ask the person making the decision to assess whether there is harm?
No, they do not.
The assessment of compliance or otherwise with those policies in context of this proposal,
Yes.
your utilisation of the role of Mr. Ingham,
Yes.
has he assessed those features?
He has. Yes.
In respect of his assessment of those features, does he consider that there is conflict or accord with those bullet point features?
He considers accord with every bullet point.
Insofar as you have dealt with anything which goes further or beyond that, can you have a look, please, at paragraph 614
Of my proof.
of your proof of
Yeah.
evidence?
Yes, I have that.
How do you express the consideration of that issue?
I presented it as the question for the inspector in this case is whether the benefits of the proposed development are sufficient to outweigh any impact in landscape and visual terms.
You go on to then deal with at and indeed ST1, which I'll come back to in a moment. Can I invite you, please, to read through paragraph 621 of your evidence?
Yes. Yes, accordingly, if the inspector were to consider, contrary to my evidence and the evidence of Mr. Ingham, that there were some conflict with the policies of the development plan, the tilted balance would apply, such that planning permission should be granted unless the benefits of granting permission are significantly and demonstrably outweighed by the adverse effects of the development.
And you continue on with the next sentence.
Yeah, if the inspector was to attach any weight to the council's alleged harm in landscape and visual terms, I'm of the view that this would not significantly and demonstrably outweigh the considerable public benefits.
So far as the council's contentions relating to harm, were those matters that were within the terms of your evidence for the purposes of the assessment of this issue under this heading?
Yes.
Thank you very much. Can I ask you next, please, to take up the NPPF? think is S13.
I've got the hard copy.
Thank you very
Yep.
much. Essentially, to understand the nature of the approach to the consideration of policies in the NPPF, you were asked to consider whether or not policies NE3 and SDC1 were themselves in conformity with the terms of the NPPF,
Yes.
and you have already given the evidence written, otherwise and confirmed orally, that in your view they are broadly consistent.
Yes,
The
particularly
NPPF.
with paragraphs 130 and 174B.
Thank you. Can I ask you to look first of all at paragraph 3 of the NPPF, and if you kindly read that to yourself.
Yes.
If I can ask you then next to look at paragraph 11,
Yes.
and in particular 11D.
Yeah. Yes.
On 11D2, how is the assessment of policies within the NPPF to be undertaken?
It would refer. Sorry. Yeah, I don't.
Yep. When you're looking at 11D2,
Yep.
and if you look at paragraph 3,
Yeah.
how would you carry out the exercise of looking at the NPPF?
You would look at all of the paragraphs together.
In looking at paragraph, for instance, 174B
Yes.
of the NPPF, would there be simple conformity, in your view, between 174B and the NPPF in the terms of the NPPF if one looked at it in isolation rather than as a whole?
Yes.
As far as the NPPF is concerned, how do you look at it? So if you're looking at paragraph 174B,
Yes.
in your view, do you deal with it in isolation, or do you deal with it as part of the suite of policies contained within the NPPF?
It's part of the suite of policies in the NPPF.
When assessing within paragraph 11D whether policies most important for the application are out of date, and what are the most important policies for determining an application, is one to look, in your view, solely and exclusively at NE3 and SDC1?
No. It would be to the provisions of the framework.
If in assessing the provisions of the framework,
Yeah.
including, for the sake of argument, 174B, one did not have regard to the other relevant provisions of the framework, how would that leave a consideration of that? Would you be dealing with a policy which, in your view, is consistent and up to date, or inconsistent and containing potential omissions?
It would be inconsistent.
Would that inconsistency, in your view, arise in the consideration of all applications? So, for instance, if you were dealing with a house building matter, would an omission to deal with, for instance, lorry parking, be relevant as
No.
to whether or not the policy was up to date or not?
No.
Is that the position in context here?
No.
SDC 1 of the local plan, if you can please
Yep.
bring that back up before you. CD12, S12, I beg your pardon.
Yes, got that.
I have that on the PDF page 82 of 167, which is, I think, on page 78.
Page 77, I think.
77,
Yeah,
beg your pardon. Mine bounces me around. So it's page 77, thank you for that. SDC1 in respect of sustainable design. So as to understand in respect of sustainable design, is there anything in the nature of that policy which deals with question of harm so far as is relevant here?
No. There isn't.
Does this policy, in itself or by linkage to any other policies, provide a mechanism for recognising the importance of overnight lorry parking, etc.?
No, it does not.
Thank you. Can I go back to your proof of evidence? And you were asked questions about countryside location. This was, I think, in context of your proof,
Yes.
415.
Is there a particular paragraph number,
I
sorry?
think it was 4.15
Ah, yes.
of your proof, page 18.
Yes.
First of all, a perhaps philosophical point, but it is a planning point. As a matter of looking at a piece of land, if undeveloped, is it open countryside, or to be more precise, not open countryside, simply because it has an allocation for another use involving built development?
Sorry, could you repeat?
Yes, it's an
thank you.
undeveloped piece of land,
Yeah.
or as yet undeveloped piece of land. Does it in character terms cease to be open countryside by reason of the fact that it has an allocation?
No.
The question of the allocation, is that relevant to the consideration as to the acceptability of future uses on that site?
If there's an allocation on a site, it would be relevant, yes.
Now, so far as non-countryside locations are concerned, so far as the strategic road network is concerned, particularly, I think, not just in the locality, but in the wider area, does the strategic road network go through non-open countryside locations?
In terms of the wider locality,
Either the immediate locality or wider locality, for the purposes of framing your answer.
I believe it only goes through open countryside within that location.
Thank you. You referred to Magna Park. Is there any lorry parking in Magna Park?
The only provision for lorries is to enable docking and unloading. There is no designated lorry parking facility.
Thank you. You were asked about alternatives and whether you'd looked at any. Were any alternatives put to you that were in non-countryside locations?
None whatsoever.
Has any been identified by the local planning authority?
No, nothing at all at any stage, not at the pre-application stage in particular.
Thank you. Now, you also had questions put to you which contained as part of them a narrative about nearly 50% of parkings, of lorry parking within the East Midlands are by those off-site.
Yes.
I think we've largely dealt with the numerical issues elsewhere, but could we please look at the 2022 study?
Yep.
This can be a relatively short point, I think. It's S15.
Yes. I have the hard copy.
Can I ask you to please go to... Bear with me for a moment. I need some more of my white port.
Take a moment if you need to.
Thank you very much. Only another 5 more bottles.
No, that's all right.
I'd like you to go to table 5.1, which I'm just going to try and find my way to. It's on page 65 of 142 on the PDF, which is, I think, page 56.
Sorry, 56.
56 of the hard copy.
That's table 5-1.
That's the one
Yep.
just dealing with the East Midlands.
Yes.
We see there number of on-site facilities 49, vehicles observed on-site 2443,
Yes.
overall on-site capacity 2661, and the excess number of vehicles 1191.
Yes.
Just looking to understand in terms of the numbers who are otherwise parking elsewhere, the number of vehicles observed on site 2443 and the excess vehicles 1191. Do you have a calculator available to you, Mr. Holmes? Just looking at that 2443, which were those parked on site,
Yes.
those that were not parked on site for the purpose of the survey, the 1191, I make that as a total of 3634. Do you get that?
Sorry, vehicles observed on site 244.
3.
Sorry, 2. Yep.
I get the addition of those to come to 3634.
Sorry, could you repeat the calculation?
Yep, 2443
Yep.
plus 1191.
Sorry, yes. 3634.
I get that to be a figure of, say, 3634. It seems to me that those who are parking off-site for whatever reason is the 1191, over the overall figure of 3634.
Yes.
I make that 32.77, let's call that 33%. Do you get
Yes.
a different figure to that?
No, I think that would be correct. Yep.
As part of the narrative to your question, that essentially up to almost half do that, do you think that's a correct representation of the 2022 figures?
Not sure. Sorry. Sorry, I'm not sure.
Because that was the contention put to you,
Yeah.
that something near to half were actually parking off-site. Would that accord with the numerical exercise which we have just undertaken?
No, I don't believe it would.
So far as a shop, supermarket, something of the nature of that as described, as far as any other truck stops are concerned, are such facilities absent or present in your view?
Present, cited one example, the Lim truck stop, which does include a shop.
Now, is that shop basically just sort of a little kiosk stuck in the corner somewhere, as far as you're aware?
No, there's a reasonable offer there. This is a convenience goods offer. In fact, I think there was WH Smith's as well. So yes, it's far more than just a kiosk.
Thank you. The Proving Illustrative Layout Plan, ID5, in terms of the space shown there, referable to any of the points made by Mr. Weeks in his evidence, your view, please, is there adequate space within the site to accommodate whether it is the buildings, the PFS, car parking, lorry parking facilities, etc.?
Yes, and I feel that the plan demonstrates that.
Thank you very much indeed, Mr. Holmes.
Thank you.
So,
Just a few questions, clarification, please, Mr. Holmes. Firstly, in re-examination, you were asked about the type of facilities that go with truck stops and refueling stations. I presume it's not petrol, it's more like diesel stops. But I think you were asked a question and you responded about, is it the Lim truck stop?
Mm-hmm.
And you asked about the type of facilities or type of goods in that shop. Do you know the sort of approximate floor area of that?
Not approximate, I'm afraid.
Right, okay.
Yeah.
Are there any other Corley or Eddie Stobart that you know of that do have that?
I believe it's a bit further away, but the Ashford International Truck Stop. Certainly, I mean, I haven't obviously visited there, but certainly those details are on the website.
Okay.
There's quite an array of goods that's sold.
Okay. Now, I haven't seen the latest conditions, so forgive this sort of question. Is it intended that the cafe would be conditioned so it's a 24-hour use, or is that just up to the individual operator?
I think it would be up to the operator, but that's not to say we'd be adverse to that condition.
Okay, but so well, it's up to, I say, it's up to you to phrase that how you want. I mean, I think I'm right, aren't I, that the motorway service areas have to have that by law, but
Yes.
I think I'm right in saying there's no such requirements on away from the motorway.
I believe that's correct,
think,
sir.
I think I'm right on that. Okay.
I would agree with that.
Okay.
Thank you.
All right. I mean, and also in terms of the hotel, would that be any restriction that it's just HGV drivers only, or would that be at liberty to other users?
No, generally they're provided without restriction. However, what I would say is that there is a difference in the offer between that and what you would ordinarily get with a travel lodge, for example. So that will probably be single beds for drivers. They're not geared up for really the domestic traveller or those, you know, travelling for leisure holidays, whatever it is.
Okay. I haven't really had a proper view round Magna Park, but I will do so Wednesday next week. But I mean, in your view, would you say that the park's constrained in terms of future growth?
In terms of lorry parking facilities,
Well,
or
in
just
terms of
general?
everything, in terms of new distribution sheds or whatever, or, you know, has it got room to expand in terms of its growing development?
There's potential to expand a little bit, as I understand it. The majority of the allocation is either built out or indeed the subject of the extant planning permissions.
So there's an allocated area in, I forget which district it is, but
Harborough.
in their local plan, and then
Yeah.
anything else would have to be obviously subject to a local plan review, or
Oh, indeed.
or yeah.
I would
application.
imagine it would almost certainly be through the promotion of an allocation in
Yeah.
due course. Yeah.
Okay, all right. Well, thank you, Mr. Holmes. That's
Thank you.
all my questions. So thank you. Right, we're coming up to 1 o'clock, which is very good timing indeed. Just in terms of this afternoon, can I just ask a clarification whether there'll be a costs application?
No, sir.
Right, okay. I've put myself a list that I need to agree dates for Section 106, and also agree dates for correspondence in terms of conditions. So hopefully both advocates won't allow me to forget that this afternoon. In that case then, shall we adjourn for an hour for lunch?
So if we may
Go on.
just have a little longer, I think
Yeah, I
for two
appreciate-
reasons.
Yeah.
One,
Yeah.
closing submissions need
Yeah.
to be finalised,
Yes.
and secondly, it will enable us to have hopefully a conversation on
Yeah.
conditions
Yeah.
as well,
I-
if only in brief.
Yeah, no, I'm quite amenable. So how long would you like for lunch?
Hour and a half?
Yeah, okay,
Thank you.
I'm quite happy with that. So we'll adjourn till 2:30 then. So that'll be closings by the council first. Yeah, thank you. Okay, so it's 3 o'clock and the inquiry's resumed. I think we've got to agree some dates of conditions and the unilateral date as well.
So that's right. In terms of the date for the unilateral to find its way to you, I hope that I'm not being unduly pessimistic on timings, but just as out of an abundance of caution, if I could ask for 2 weeks, i.e. 14 days, in order to be able to get the executed document to you, which would take us up to the 26th, I think.
Yeah, well, if we say 27th,
27th.
that's, I know some inspectors are slightly more difficult, but I think 2 weeks is quite reasonable, really.
Thank you, sir.
Yeah, so if we said at end of the day on the 27th of January.
In terms of what you would like to see, sir, or like to receive, would you like it in electronic form, or would you like to receive a hard copy form?
If I could have both, so if on the 27th, if an electronic copy could go to the case officer, and thereafter a paper copy in the post would be great, thank you.
Certainly, sir. Thank you. I'm grateful for that indulgence.
No, that's, I personally, I think 2 weeks this day and age is perfectly reasonable, yeah. Okay, so we've also got to agree dates for conditions. So those conditions are being, excuse me, finalised between the parties. I don't want to curtail that discussion. So when do you think that would be?
So obviously I'm happy to be at Mr. Holmes's availability for that. So Mr. Holmes obviously being the first instance, and I'm happy to assist from afar if that's required. Doubtless those discussions can take place over the course of the next 2-3 working days.
That's absolutely fine. Yeah, thank you.
Okay.
When would be convenient for you, sir, to receive the product of that exercise?
Well, if that could come over to me, if that could get to the inspectorate's case officer by, say, Wednesday next week, I've got another looming inquiry shortly, so I'd like to be able to get any comments to both parties within a week of that, if not less. So that'll be my commitment to you. So if we aim for, well, Wednesday the 18th, I'm out on site anyway.
So by close of play on that day?
Yes, yeah, that would be helpful.
Can I just ask one,
Yeah.
which may assist both parties, and particularly the authority? There is a divergence of views and practice among inspectors as to whether or not reasons for the imposition of particular conditions are helpful to you in the event of issuing your decision letter to grant permission. Is it helpful for you to have the reasons applied, which are, of course, the council's reasons as to why they would want it, or is it a matter where you would review the condition in its own terms and therefore not require the benefit of that particular additional paragraph?
Personally speaking, I actually do find it helpful because it confirms the intent and helps me look at the purpose and relevance to it. I personally do find it helpful, and needless to say, it would be. They are deleted by inspectors, but I nonetheless find the purpose of it helpful.
So thank you. That will doubtless assist the authority.
And similarly, I should say actually that I think the first version I saw had informatives. Needless to say, the inspectorate don't put informatives on, so that wouldn't be helpful to me. So
Reasons but no informative.
yes, yeah, thank you.
So I should probably have asked in context of the planning obligation, I may have just simply presumptively inappropriately made the assumption that you're content with its terms and don't have any queries on it. You gather that the two parties are both agreed on it as to its terms.
Yes, I was just waiting for the SIL compliance to sort of tick that box, but it was sort of alluded to in debate, and there's been reference to it in the statement of common ground. So I'm happy that I don't need to ask any questions about it. So thank you. So that probably concludes the sort of admin housekeeping. So yeah, we'll just wait for the printer, presumably.
So thank you for the additional time.
No, that's okay. I understand circumstances aren't easy to digest 3 days into a short space. So for those of you who are listening on the internet, we're just waiting for the closing statements to be printed, and then we'll resume very shortly. Okay, the inquiry is resumed, and we're starting with the closing submissions, and the council to go first. Thank you.
Sarah, I don't know what you have to do, but I can't speak at the moment. I can't.
Oh, hang on.
Yeah,
need to
that
speak,
works.
so- yeah, okay.
That works. So, just to explain what I've given you, you've got my hard copy closing submissions. You've also got two cases. You've got Wavendon, which is referred to at footnote 29 and page 12 of my closing submissions, and Paul Newman Holmes on page 13, footnote 30. So I let my learned friend know that I was going to be relying on these cases yesterday. They go to the issue about the tilted balance, which I don't think has so much relevance now, but for the avoidance of doubt, I've put them in and dealt with them in my submission so that you have what we say is the correct approach to that issue. And so with that, I'll begin. These submissions should be read together with the Council's opening statement, which set out in summary that this very large development is unacceptable, ill-conceived, apparently undeliverable, and unjustified. The Council doesn't demur from the nationally and regionally demonstrated need for HGV parking, but that does not get the appeal scheme over the line. There are many developments for which there is a need, but good planning is about understanding that need in context and balancing the benefits that arise from schemes which profess to meet those needs against any harms that might arise. The site is open countryside, and so the development has to be properly justified. Even if the appellant's case on the HGV parking element of the scheme is accepted, that doesn't justify the land use associated with those elements of the scheme which are totally divorced from it, that is the creche, a supermarket of the size proposed, the petrol filling station and the vast quantity of parking spaces to be provided. A scheme focused on the HGV parking use would have required a much lesser land take on what is presently undeveloped open agricultural land. There is inevitable and significant harm that arises in this case to the landscape character west of the appeal site. The character area in which the appeal site sits is demonstrably and obviously different to the landscape to the east, which has been and will continue to be developed for industrial storage and distribution uses. A scheme of this nature and size on the wrong side of the road would undermine the historic character of the landscape. The long-standing distinction between the two areas obliterate the landscape fabric of the appeal site and occupy a prominent local high point. The contrived structural landscaping on which the scheme relies would have the further unintended consequence of blocking and curtailing views of the open landscape while failing to integrate the scheme into its setting. At the end of the inquiry, the question marks over the scheme remain. Mr. Weeks raised serious issues in his proof of evidence, which was exchanged 4 weeks before the inquiry, and ID5 doesn't answer those questions, and if anything, it compounds the problem. A month later, and having produced a further indicative plan to respond to that, first, a number of different uses are still crammed within one facilities building, which has no service area and no outdoor amenity space for children using the creche. The plan fails to show the service station. And second, there are now 357 car parking spaces, which is well in excess of anything that was assessed in the appellant's transport assessment, for which there was no demonstrable need and which raises serious concerns about the ability of this site to deliver all of the components it is claimed that it will. While it is accepted that the scheme is in outline, there are fixed parameters because this is EIA development, and so it's necessary to assess the scheme against those. That fixes the access, the uses, the heights and the green infrastructure. And owing to those constraints and the failure by the appellant to produce a workable plan, even with multiple attempts, it is very difficult to understand how the scheme as a whole is deliverable at this stage. Turning then to the main issues and beginning with landscape and visual impacts. The scheme brings large-scale, tall, industrial development into a landscape character area that is distinct and different to the area east of the A5. The land to the west of the A5 is largely undeveloped and predominantly managed as farmland, with scattered farms, individual dwellings and small villages along and adjacent to roads and lanes. The historic mapping at Appendix 1 of Mr Wakefield's proof demonstrates that the A5 Watling Street is an historically important route that forms a distinctive feature through the landscape. The road contains the Magna Park development, protecting the undeveloped landscape beyond. Warwickshire County Council's landscape architect objected to the application due to the fundamental change to the local landscape character, and within the case officer's report, it is stated that the provision of development on the application site would be viewed as an encroachment into the countryside and the existing landscape framework being destroyed. It is right that all internal hedgerows would be lost, with the exception of a single mature oak hedge tree, which is covered by a TPO, and a significant portion of roadside hedgerow would be removed. The officer also noted that the site would be predominantly hard-surfaced and that despite mitigation planting, the proposals would not integrate within the wider landscape, as the proposed landscaping would appear at odds with the prevailing agricultural landscape. The distinctive landscape features of the spinneys, that is Long and Streetfield spinneys, have long endured in the open plateau character area. Together with other trees, they form the skyline since the site sits at a local high point. It is a place where the openness of the landscape is appreciated, but where that experience would be diminished post-development and the skyline views replaced by very large buildings and, in due course, structural landscaping with rooftops showing above. This is a site with good landscape value. The landscape quality has a clear pattern of characteristic elements, including a woodland edge on the higher ground, mature hedgerow boundaries to the north and west, a watercourse pond within the site, and it's well managed. The site contributes to the rural countryside setting of the landscape character area, despite urban influences on the opposite side of the A5. As explained throughout the Council's evidence, there is a strong distinction between character areas east and west of the A5, because while industrial development is a key feature of the Lutterworth Lowlands landscape character area, it is not in keeping with the open plateau LCA, which is primarily open and agricultural, with small settlements. While the appellant approaches the LCA in the vicinity of the site as a transitional area, Mr Wakefield disagrees. There is an obvious difference between the areas severed as they are by the clear and robust boundary of the A5. The appellant's transitional zone approach also means that any new development converts adjacent or nearby undeveloped land into the next transition zone, making it susceptible to new development. It is an approach that fails to recognise the specific qualities of the appeal site and the impact of introducing development of this nature into it. The effects of the scheme will be felt during the day and at night, when the site will emit a glow as a result of the lighting columns and the activity on site. There will be open views into the site as a result of the new access roundabout configuration on what is currently a country road, and the planting, which will be largely deciduous, will fail to mitigate all of the adverse landscape impacts in the long term. The proposals will also dislocate the farm from its agricultural setting, diminishing the experience of that building in its agricultural context and giving rise to an inevitable pressure to redevelop. As set out in opening, there has been a continual downgrading of effects as a result of the appellant's 3 attempts at assessing the landscape and visual impacts. The first assessment by ADAS formed part of the ES and called itself an LVIA. Any attempt to characterise that as a lighter touch landscape assessment rather than a full study are entirely misplaced. It is clear that the LVIA also had regard to the Magna Park extension, which it noted was under construction, and the addendum ES assessed the revised scheme with little change to the overall effects. The appellant's landscape effects have ranged from substantial and significant to moderate adverse on Mr Ingham's assessment. Mr Wakefield finds that they are major, moderate, significant at a site level, and in respect of visual receptors, Mr Wakefield is more aligned with the Pegasus LVIA, which is adopted by Mr Ingham. Mr Wakefield finds major adverse effects at construction and year 0 in respect of views from Lutterworth Road, the A5 and the Crossing Hand roundabout, with moderate effects remaining at year 15 for Lutterworth Road, Crossing Hands farmhouse and the roundabout junction. The Pegasus LVIA agrees with Mr Wakefield with major and moderate adverse impacts from Lutterworth Road and from the Crossing Hands farmhouse. In summary, the scheme will bring about that wholesale change to the site and its context. It denudes the site of its landscape fabric and character. None of the internal hedgerows will survive. The scheme promotes significant new planting because of the absence of natural screening and seeks to create a wholly new and artificial perimeter of trees and hedgerow to hide a development that is inevitably harmful, industrial and badly thought out on the wrong side of the road. It will block views and diminish the sense of openness that is presently felt when travelling through the landscape west of the A5. The effect is undoubtedly significantly harmful. Moving then to need, as set out above, the Council takes no issue with the national and regional need for additional lorry parking. The question is whether a facility of this size and comprised of the elements proposed is required and justified here. The Council says not. The size of the scheme and elements such as the crush facility have not been properly justified. The following is important context for the scheme. There is no national policy or guidance which sets out a numerical requirement for overnight lorry parking. It has been 5 years since the 2017 National Survey of Lorry Parking, and no such requirement has been introduced. Paragraph 109 of the framework does not provide a presumption in favour of such development as accepted in cross-examination by Mr. Holmes. The high point of the policy context is that planning policies and decisions should recognise the importance of providing adequate overnight lorry parking facilities, taking into account any local shortages to reduce the risk of parking in locations that lack proper facilities or could cause nuisance. Paragraph 109 of the framework does not require plans to allocate land for lorry parking, and nor does it set out any formula or approach to assessing the need. As Mr. Stack agreed in cross-examination, a target could have been provided, but hasn't been. The same policy expects that proposals for new or expanded distribution centres should make provision for sufficient lorry parking to cater for their anticipated use. That is what is anticipated to happen at Magna Park. Mr. Stack agreed in cross-examination that there is a strong likelihood of that development coming forward. The national surveys are important material considerations. Circular 0122 requires that regard should be had to the survey in understanding the identified need. Nonetheless, there is nothing in the circular, national policy or guidance that says all overnight lorry parking should be accommodated on-site. And in fact, neither the 2017 nor the 2022 survey provide a determinative view on whether off-site parking should be considered inappropriate. The matter is undetermined. It is neither practical nor necessary to accommodate all HGVs on site because drivers will park in lay-bys and on industrial estates even when there are options to stay overnight in designated spaces. The reasons for this are disparate and perhaps not entirely understood, as Mr. Stack accepted in cross-examination to provide for all vehicles parked on and off-site, plus 15% would be over-provision, because there are those who will always choose to park off-site. In the 2022 survey, half of the respondents to the survey preferred not to stay at designated truck stops. The same study set out at page 28 that off-site locations have been included as many lorry drivers still opt to park there. The reasons are being examined as part of the driver engagement, representing 35% of all vehicles observed. Whether off-site parking is to be considered as inappropriate for overnight parking is undetermined. And importantly, as set out in the Select Committee report, most HGV drivers are not regularly required to stay away from home overnight. The footnote within the report set out information from Logistics UK that in 2018 the National Survey of Lorry Parking found the number of HGVs counted making overnight stops on a typical midweek night had risen from 13,708 in 2010 to 18,670 in 2017. That represents a 36% increase for 962 vehicles. This was, however, out of a population of over 300,000 HGV drivers in 2017. Accordingly, the issue is one that affects a small proportion of drivers within the industry. Despite Mr. Goatley's best attempt to elevate the written ministerial statement and the Select Committee report to the status of national policy and government guidance respectively, the written ministerial statement says nothing more than existing policy contained within paragraph 109 of the framework, and the report has no such status. Moreover, it would appear that there was relatively limited industry engagement behind the report by comparison with the national surveys. And you'll see, sir, the footnote where that was, you have the direction there to compare and contrast the relevant parts of those documents. Moreover, the report was published on the 1st of June 2022, and despite its recommendation at paragraph 51, that has not been translated into government planning policy, including the recent draft amendments to the framework straightforwardly. it is not government policy that all vehicles parked overnight should be accommodated on site. As to the quantitative level of need, the 2017 survey considered that the immediate response to the need, which focuses on lorry parks at over 85% utilisation, was to increase capacity by 303 spaces across the whole of the East and West Midlands. Mr Stack disagrees that an approach based on the capacity of lorry parks is correct, but the 85% exercise is one that the appellant drew upon in its planning statement, was included in the PJA statement appended to the statement of case, and which indicates now that an immediate response, updated with 2022 inputs, should be 181 new spaces across both regions. Accordingly, the proposal here, which is well in excess of that, and in just one location, is not justified. Since 2017, there has been additional capacity that has come forward in the region, including 88 spaces at Rugby Services, which is just 5 miles from the site and obviously popular, and an additional 93 at Crawley Motorway Service Area, which is within 20 minutes of the appeal site. There is clearly merit in expanding existing parks, and the circular recognises that to be the case. There are developments in the pipeline at Magna Park for which there is obvious policy support and outline consents, and as Mr Stack agreed in cross-examination, has a strong potential to deliver new capacity. The latest application, which is called document S35 in particular, is embedded in Magna Park, has a strong fallback, and complies with national policy set out in paragraph 109. A further permission is at Cold Ashby Welford, which has permission for 82 HGV spaces within 20 kilometres of the site. Nationally, between 2017 and 2022, the overall number of vehicles observed by the survey has increased by 2,564, up 14%, and the numbers of vehicles on site have increased by 22% to nearly 14,000. That is the largest proportion of vehicles observed, and the number of lorries in laybys has decreased, but those parked on industrial estates has increased by 669 in total, a figure which is comparable to the decrease in lay-by parking. So there are many positive indicators in those figures. In respect of on-site utilisation, the East Midlands is now up from 72% to 92%. And while that may appear like a negative thing on first blush, it actually means more lorry drivers are using lorry parks than previously. That is a positive on the appellant's case that all vehicles should be accommodated on-site, but also means that extra space is required. Utilisation in the West Midlands has decreased. Doing a compare and contrast between 2017 and 2022 surveys is a helpful and enlightening exercise, which demonstrates that all of the indicators except one are positive, and I set those out, sir, together with the references in the table, and the final figure of 438, which is footnoted with footnote 20, it is the only negative change, I say, as agreed by Mr Stack in cross-examination. What those figures mean is that capacity has increased in both areas since 2017. The number of lorries using on-site parking has increased while off-site parking has fallen. It also shows, however, the continuing pattern, particularly in the West Midlands, of drivers parking off-site despite there being capacity on-site. As to the PJA information that was produced after determination of the application, its scope and methodology was not agreed with the local planning authority, and it provides only a snapshot of conditions in the local area. It does not apply the same methodology as the national surveys, which were subject to pilot studies, longer survey times and verification. The national surveys inevitably cover a much wider geographical area and present a vastly broader data set. By contrast, the PJA surveys were undertaken between the hours of 7 p.m. and 9 p.m. only, and the local picture examined locations within 6 miles of the appeal site and considered that an additional 62 spaces were required to achieve 85% utilisation at local truck stops. In terms of the regional picture, there is a mixed bag of capacity, with capacity in the east and west exceeding the lack of capacity in the north and south. In terms of off-site parking, PJA considered a fraction of locations considered by the national survey, 20 versus 470 laybys and 4 industrial estates versus 115, concluding that the position is worse now than at the time of the 2017 survey. The exercise compares apples and pears. Fortunately, the 2022 survey presents a different, comprehensive and much more positive picture that can be relied upon. As to the qualitative need, it is fair to note that better quality facilities cost money and people will not always want to use them. That is a preference outside of the control of the appellant, and so while it's a good thing to provide high-quality facilities, that is not necessarily going to attract drivers to abandon free parking if they are unwilling to pay in the first place. Further, when looking at the ratings of lorry parks in the East and West Midlands, they are broadly consistent with the national average. There is not some unusual or unique issue in respect of these regions. As to other facilities, and as outlined above, there is no justification for them, and the case that is made in respect of HGV parking need does not apply to them. The creche is perhaps the most unusual and frankly strange element of the scheme. No evidence of a need for the scheme has been presented. It's to be housed in a building visited by hundreds, if not thousands, of people a day, which raises potential safety issues, and there are no outdoor amenity spaces provided. It is not an attractive environment for children to play and learn. The supermarket is large and significantly larger than a convenience store, provision of which is usually below 280 square metres to avoid Sunday trading restrictions. Given that the site is promoted as an overnight lorry park and lorries are generally occupied by a single driver, the viability of that shop obviously depends upon non-HGV custom. As Mr. Weeks explained in evidence, there are plenty of similar facilities nearby, including at Lutterworth. There is no need for a facility of this size which provides retail floor space in addition to that at the petrol filling station. In respect of the non-HGV petrol station, there is no shortage of local facilities, and the same goes for the cafe. See Mr. Weeks' rebuttal, which was not seriously challenged by the appellant. Accordingly, the need for those additional facilities has not been demonstrated, and the weight to be attached to them is seriously diminished. As to the approach to the planning balance, Mr. Holmes accepts that he has not carried out a planning balance because he has had no regard to the harm that would arise from the scheme. The appellant was also wrong to say that the tilted balance is engaged. Mr. Holmes conceded the point in cross-examination, but for the avoidance of doubt, it is not engaged and there is no reasonable way of getting there. And that's for the following reasons. First, framework paragraph 11C and D set out the approach to decision-taking. The appellant does not say that 11C should apply because it does not regard the development plan as up to date. Second, the next question is whether the framework paragraph 11D applies. The paragraph itself sets out the ways in which the tilted balance might be triggered. The first is where there are no relevant development plan policies. That is obviously not the case here. The scheme was refused on the basis of policies NE3 and SDC1, and Mr. Holmes accepts that they are the most important policies. The second is that the policies which are most important for determining the application are out of date. Footnote 8 does not apply here, and Mr. Holmes accepts that both NE3 and SDC1 are consistent with the framework. Accordingly, there is no route through paragraph 11 into the tilted balance in this case. It is also entirely unclear how the appellant can conclude that the absence of a policy on lorry parking can render policies concerned with sustainable design and landscape protection and enhancement, and which are consistent with the framework, as out of date. It makes no sense and is not a gateway set out in paragraph 11D. As to the basket of policies being out of date, first, this was not a point taken by Mr. Holmes. It appeared for the first time in cross-examination of Mr. Weeks and is a bad point. Second, the need to consider whether the basket of policies is up to or out of date arises from Wavendon, which provides for the following. To answer the question posed by paragraph 11D, it is necessary, having identified those policies which are most important for the determination of the application, to examine them individually and then consider whether taken in the round, bearing in mind that some may be consistent and some inconsistent with the framework, and some may have been overtaken by events and others not, whether the overall assessment is that the basket of policies is rightly to be considered out of date. That will, of course, be a planning judgment dependent upon the evaluation of the policies for consistency with the framework. See paragraph 212 and 13 taken together with the relevant facts of the particular decision at the time it's being examined. Mr. Goatley's point is that a policy on lorry parking is absent, and so the development plan is silent on the matter. Accordingly, it is not part of the basket to be assessed, and its absence from the basket can't turn what the appellant accepts are up-to-date policies into out-of-date ones. Finally, absence and silence are concepts confined to the history of the 2012 NPPF, as was made clear in the Paul Newman Holmes case, in which Lady Justice Andrew found as follows, and I'll just read the first part, that the word absent and silent have gone. Cases on their meaning do not assist in the interpretation of the language that was used in their place, which is deliberately and materially different. And so I've given you a larger extract there to read at your leisure. So over the page, point 9, it was put to Mr Weeks that the local plan should have included provision for lorry parking, since a need for lorry parking was known in 2017 and before the plan was adopted. If that argument is a good one, the plan was out of date on the day it was adopted. The approach is illogical. Finally, even if there was any merit in the point in respect of the tilted balance, and there is not, policy GP2 of the local plan is worded permissively, so that new development will be resisted in the countryside, but can be permitted where national policy on countryside locations allows. The Council did not refuse permission on the basis of policy GP2. As set out above, paragraph 109 of the framework does not amount to a presumption in favour of this development. It is a material consideration, but its support for lorry parking facilities, I think the four's additional, does not trump other policy considerations or, most importantly, the development plan. Set against paragraph 109 of the framework in this case is the policy support for recognising the intrinsic character and beauty of the countryside. There will be both adverse landscape and visual impacts as a result of the scheme, and that is a harm to be weighed in the balance. It is telling that Mr Holmes fails anywhere in his evidence to acknowledge that straightforward and rather obvious point. Mr Weeks' concerns about the scheme remain in respect of the ability of the scheme to deliver the individual elements applied for. In summary, they are as follows. The latest illustrative master plan improving layout demonstrates a very significant change in the anticipated arrangement of the site. The later plans show the toilet, shower, cafe, accommodation, security shop and creche all being delivered in one building. There is no evidence as to how those varying uses can all be acceptably accommodated within a single building. That is particularly for the creche, for which demand is unknown, having regard to the needs of that type of development and the absence of any outdoor space for children to play in. There is no service yard for the building or accommodation for HGVs making deliveries. As a result of the amendments to the proposed green infrastructure, also set out on a separate parameters plan, the area to accommodate those uses has reduced from 21,000 square metres to 15,000. Again, there's no evidence to demonstrate the scheme as promoted can be delivered on the much reduced area, and the same point about reduced areas can be seen, for example, with the HGV truck wash, fuelling and kiosk area, where there is now insufficient room for HGVs to turn. That wasn't remedied by ID5, which was apparently produced to meet Mr Weeks' concerns. The upshot of all that is that the scheme cannot deliver what it proposes and the benefits are diminished as a result. Something must give, although it's not clear what the something is. Alternatively, the scheme takes up way more space than is actually needed, considering there is absolutely no justification for over 350 parking spaces, a creche, a large supermarket to support a scheme that allows lorry drivers to park overnight. There are real doubts over what the scheme is trying to achieve and what benefits attach to it. In conclusion, for all the reasons set out above, the scheme is ill-conceived, environmentally harmful, and the benefits, many of which are uncertain to be achieved, do not outweigh the harm. The scheme conflicts with the most important policies and the development plan as a whole. While the need for lorry parking attracts significant weight in the planning balance, that need has to be viewed in its proper context and does not overcome the significant landscape and visual harm caused by the scheme. Accordingly, sir, we invite you to dismiss the appeal. Unless I can assist you further, those are my submissions.
Thank you. I just wonder if it's prudent to have a very short comfort break now.
Probably wise.
Yeah, okay. Shall we adjourn for 10 minutes then?
Thank you, sir.
And commence at 5 to 4. Thank you. Okay, so 5 to 4, the inquiry's resumed and closing by the appellant, Mr. Goatley.
Sir, thank you very much. You've got my written closing, but before I turn to that, if I can make some observations in respect to my learned friends' closings, I'll do so by reference to the paragraph numbers in which they appear. Now, the first is an overriding point, or an overarching point, that will emerge from not only the terms of the closings, but also with respect to the Council's approach to the consideration of this proposal at appeal, which has been to, in many ways, elevate the appeal and the appeal proposal to a detailed scheme to which it is then subject to a fine and forensic analysis. With respect, that is not appropriate and perhaps might be said to be more suited to an exercise in trying to find the cracks in a pavement rather than the pavement itself. Second paragraph was somewhat reminiscent of Shakespeare's recitation of Mark Antony dealing with Brutus, that almost lachrymose with crocodile tears, the Council does not demur from the nationally and regionally demonstrated need for HGV parking, but basically doesn't want it here. They tell us that the site is in open countryside, and so the development has to be properly justified. One could take a very short point to that, and indeed a short point in NPPF terms, that there is a specific policy in paragraph 109 which does provide that justification, and that then meets something which has perhaps ethereally flitted in and out of the inquiry, which is GP2 of the local plan. If so, then that particular issue is resolved and explained. A matter also within paragraph 2 talks about the vast number of parking spaces to be provided. So, sir, you will recall that the planning application does not itself deal with the number of parking spaces other than those for HGV parking, which was the subject of amendment. But the gist of the criticism is that on some inchoate and unparticularized basis, the scheme could have been somewhat less. The Council doesn't tell us what or what that may be, but all of that, with respect, is to fundamentally miss the point that it is an outline scheme simply subject to parameter control. So with respect, all of those points are wholly misplaced and ought to be rejected. So the next point is in respect to paragraph 3 And this also has relevance to paragraph 11, so the 2 paragraphs for these purposes might be elided. And this relates to a contention about a boundary formed by the A5. Now, I specifically asked Mr. Weeks about that, and could he point to any document that provided such a boundary in policy terms, or indeed where it had been explicitly considered by the Council for policy purposes? And there is none. The most that you get is that you have 2 adjacent authorities who have carried out separate landscape character assessments that do not stray beyond their administrative borders. Unsurprisingly, there are 2 character areas and which have been subject to different processes of characterization and description by different consultants and authorities. So be it, not a matter of criticism to it, but that is then elevated to being a boundary. With respect to Lawrence of Arabia, what that might have meant for Sykes-Picot in terms of being able to introduce boundaries perhaps would even make him blush. So in 4A and 4B, we've got a reference to cramming of facilities. There's no suggestion that the facilities will be crammed. There's no evidence of cramming. And the 357 car parking spaces, so as was being explained, I think ad nauseum, is to show what space is available to accommodate any uses or dispositions that might thereafter apply as a matter of detailed consideration, beyond that which is embossed by the parameter planning process. And that then culminates in this aspect in paragraph 5 of elevating a necessity to show what's described as a workable plan. There is a workable plan. It may not meet all of the council's alleged concerns, but it is more than adequate in my respectful submission for the purposes of demonstrating the deliverability and workability of the site. In paragraph 7, there's a reference to large-scale, tall industrial development. So I invite you to simply compare, 1, what is there at the moment, and 2, especially that which is in Magna Park, which appears to come in and out at will and whim from the authority's position, but in reality is a landscape impact of materiality, and is one which impacts upon character and views, as we will doubtless return to. In paragraph 10, we have the contention that the site has a good landscape value, so I'll leave that as a matter for you. But that is to recognise this is an area which has no designation in landscape terms, is accepted not to be valued, is not in the green belt. And is one which has not been identified as having some specific value that elevates it. I didn't know there was a dentist in the building.
Sorry, Mr. Goatley, do you want to come back a few
Should we just
sentences in
should we just see
pause
how
it?
that? Should we pause that for a moment?
Let's pause for a minute.
I blame my learned friend for this.
I don't want to tempt fate, Mr. Goatley, but I
Should
wonder
we
if-
restart and then see whether or not we're tempting fate?
Yes, yes. Do you want to come back a few points? You're talking about landscape value and it's not designated or valued.
Not designated, not valued, not green belt, not an area that's said to have a setting to any of these things, nor has it been identified as having any particular landscape qualities or sensitivity to take it out of the ordinary. So in short, it is being somewhat elevated in its terminology, both there and indeed in the Council's contentions to you. Now, I've already dealt with the boundary issue in about paragraphs 3 and 11, and I will not continue on with that further. Paragraph 12, and this is the gravamen of the contention made, is that the landscaping, and this is in the penultimate and last line, will fail to mitigate all of the adverse landscape impacts in the long term. So, firstly, we don't accept that. Secondly, to the extent that there are any impacts, the landscaping scheme is one which will be effective. Thank you very much indeed for finding the errant dentist. Next, to paragraph 14 and the continual downgrading. So I thought it was a matter that sort of died a death, but apparently the contention is made that the ADAS study was an LVIA and not an LVA. So if you have a look, please, I'll leave it to you for your reading. It's CDA 15.1.
Sorry, can you repeat that? CD?
CDA 15.1. There are at least 4 references, one of which is the one at the outset, 6 of 51 of the PDF, which makes clear that it's an LVA, not an LVIA, and uses that terminology repeatedly. So it is and was at all times badged as an LVA. It's not being unduly critical of it, sir, but it's simply that when Pegasus came along, what they did was an LVIA, which is a more detailed exercise. Paragraph 16, and this appears to really be the top and bottom of this point. The scheme will bring a wholesale change to the site and its context, it is essentially the site that will change. So it's a matter that you have already had some opportunity to experience, and you will do so on your further site visit next Wednesday, as well as the evidence you've received. But the views available of the site from its exterior, i.e. its context, if that's the terminology used, are really very limited. So I turn to the issue of need in paragraph 18, and there are a number of what may be characterised as straw man contentions, i.e. the proposal is not this and it is not that, or there is no policy like this or that. None of those are matters that were contended for by the appellant. We do not contend, as in B, that there's a presumption. What it is a specific direction to recognise the importance. Strong terminology. Paragraph C, about paragraph 109, not requiring plans to allocate land. The NPPF requires just about really very, very little. It indicates what the policy is, and doubtless that will come to be considered in context of plan making. But circumstances indicating requirement, there are few. So that is, with respect, not a well taken point. Similarly, F, about nothing in the circular, says all overnight lorry parking should be accommodated on site, and the matter is undetermined. So one, you have the benefit of the various other instances of policy formulation, including the Common Select Committee report, from which the government has explicitly failed to demur, to use a term. But paragraph 109 itself is really pretty clear from an interpretation point that planning policies and decisions should recognise the importance of providing adequate overnight lorry parking facilities. So it's adequate overnight lorry parking and facilities, taking into account any local shortages, to reduce the risk of parking in locations that lack proper facilities. There is no evidence before you to gainsay that of Mr. Stack that a lay-by or an industrial estate which does not have security, toilets, washing facilities, ability to get food, water, sustenance, that those are in any way to be connoted as being locations with proper facilities. In that instance, this is an illusory point, and it is clear what national policy requires. Within G, it is stated in the last sentence that Mr. Stack accepted that to provide for all vehicles parked on site and off site plus 15% would be over provision. So I don't believe he assented to that in that way, but so I'll leave you to your note. He did accept there would be those who would park off site. I said within H, this is the half of respondents to the survey preferred not to stay in designated truck stops, That's a matter I'll return to in my own closing submissions, but I would invite you to look at table 5-1 of the 2022 study, as to indicating the extent of unmet need in the locality, and that how that correlates in the East Midlands is much nearer to effectively a third than anything like a half, irrespective of what was in that particular survey. As to item I, that really this is somewhat de minimis, and it affects only a small proportion of drivers within the industry. So that is an effect sufficiently significant, that effect sufficiently significant to be dealt with explicitly by the Select Committee, who wish to see more even than that which is contained in paragraph 109. Now, I am somewhat upbraided in paragraph 19 for having the temerity to have asked Mr. Weeks about the written ministerial statement, Select Committee report, circular, and other documents there. So you will have your own note of the concessions made by Mr. Weeks as to what those documents abundantly clearly convey as being the response, and a response consistent with government policy and what that requires. So the approach at reading down that is advanced is unwarranted, as it is unhelpful. Now, within paragraph 20 is a point which again permeated the authority's case, which is to conflate the immediate response technique with the use of the 85% practical capacity assessment. The immediate response only appeared in the 2017 document, not anywhere else. The 85% remains as a good practical guide. They are not the same, and they are not to be conflated. As to do so, that would be, in my respectful submission, a genuinely profound error. In paragraph 21, there is reference to the merit in expanding existing parks. There's no evidence that beyond those subjects of consideration at this inquiry that anyone's suggesting expanding anything. Now, I would ask you and invite you, when looking at the recitation of figures in paragraph 22 and following, to consider all of the evidence before you, including that within the PJA survey, as well as Mr. Stack's evidence. A matter I'll return to shortly, because however you dress it up, where you get to is that although there may be more who are parking on site, 1,191 people drivers in the East Midlands are parking off-site. and that assumes a 100% utilisation. Combining that together with the West Midlands and the need to upgrade by at least 15% for that increases that figure. And that makes no allowance for the excess of 85% at any of the other facilities. The subject not only of the PJA evidence, but also, for that matter, in the 2022 study. Now, again, within paragraph 28 is an attempt to read down the utility and value of the PJA study. I would invite you to reject that. It is not, and never was intended to be, an emulation of what is now contained in the 2022 National Lorry Parking Survey. But what it does do is to provide local granular detail in order to understand what is going on locally. And as Mr. Weeks accepted, that, together with the two national lorry parking surveys, represent not only the best evidence before you, but the only, because the authority has no evidence of its own. It simply wishes to critique the work of others. Now, paragraph 31 looks at other facilities. In order to have adequate facilities, so it is necessary to look at all of those within the rating level system and within the label rating system. That goes beyond simply providing a car park. It also goes substantially beyond just providing a fence around the car park insofar as security is concerned. It contains all of those features that have been discussed, including those for accommodation, those in respect of washing, toilets, convenience store, food, refuelling, and we would say those things relating to repair. If I can go to paragraph 34, it's contended that Mr. Holmes had no regard to the issue of harm. So I'd invite you to look at paragraphs 6.14 and 6.21, as well as my closing. So I'll also invite you to go to and consider the issue of the tilted balance. We are told in paragraph 34, and including paragraph 34 Roman 5, that there's no route through paragraph 11 into the tilted balance in this case. So with respect, that is just incorrect. And I would simply invite you to reject that contention. A matter I'll return to later, but so as there is no absence of clarity upon that point. We consider that the development, first of all, complies with the development plan 11C. So far as 11D is concerned, the policies most important for determining the application contain an important omission. we know from paragraph 3 of the NPPF, one needs to read the needs to read the NPPF as a whole. In context, both of the policies concerned, NE3 and SDC1, in terms of their own material, are consistent with the NPPF. But they're only consistent with the NPPF in circumstances where read as a whole, they would also contain a policy of the like contained in paragraph 109. They don't. And it is in that instance that it is necessary to consider, when applying and interpreting those policies, whether they are out of date as part of a basket. So far as Wavendon is concerned, that deals with the basket. I have a little recollection of that. I appeared in it. So far as Newman Homes is concerned, that takes us nowhere. It's certainly not on point. It's contended that I was advancing a case that lorry parking is absent, and so therefore the development plan is silent. I did not make either of those contentions at any time during the past 3 days. So with regard to policy GP2, it's item Roman 10 of paragraph 34. With respect, that point takes the authority, I would respectfully say, not to where it ought to be. And the reason why it does not do so is because that is permissive of development in the open countryside. There is nothing there or elsewhere that recognises the importance. That's the critical component, recognising the importance of what we're dealing with here. So, thank you. Those are all the points I would like to make on that. If I may, I'll turn to my own closing submissions. Now, set out in opening, this proposal is an important one to meet an acute but long-standing need for additional appropriate overnight lorry parking facilities. As is evident from the material before the inquiry, the site is located adjacent to an important cluster of highway networks, the M1, M6, M69 and A5, and a large and regionally significant logistics and rail freight hub of Magna Park and Derved. In respect of the Council's principal issue for refusing permission, landscape, as is set out below, the impacts are limited, and to the extent that they arise are significantly outweighed by a need recognised in national policy for its importance. The Council indicated in opening that it doesn't take issue with the national need for this type of facility. Plainly, that's the only position which the Council could take in circumstances where the need is overwhelming. The Council's case is now that this is a facility which is too big for this location, and in the absence of a numerical target, that it should not be seeking to address the needs of the East and West Midlands in this location. Before moving to consider the merits of those propositions, we make 2 important points. So it will not be lost on you that the ongoing failure to provide appropriate HGV parking and other facilities has a profound personal impact on the quality of life of drivers. The consequences of not providing enough facilities, all the right amenities, are sadly now well documented. It affects where drivers stop to use a toilet, where they can eat, and what they can eat, whether or not they can wash, and where they can rest. The facilities available in a cab are basic. The impact on drivers ought to be an important material consideration in this appeal, particularly when increasing difficulties relating to the retention of drivers ultimately gave rise to a crisis as recently as 2021. This is also a matter of national importance. The strategic and planning issues are also well recognised. Please see the regional planning documents, the national level of the DfT's Future of Freight long-term plan, in the House of Commons Select Committee report, in national policy, and through discussions at the highest level of government, for example, the written ministerial statement. The Minister of Roads, Buses and Places also underlines the important contribution that hauliers make to the economy. She is sharply aware of the concerns expressed by many drivers and operators about the provision, quality and value of lorry parking in the UK. The need for more facilities and of better quality is a theme which runs through them all. As highlighted above, it is recognised in the NPPF, both this and the previous versions, though not the 2012 version. Given the Council's concession on a national need case, we don't dwell upon it further, but that does not detract from its gravity or its severity. To address the Council's case, we need to consider the quantitative need in East and West Midlands, the need in this location, and the facilities in place to meet the need, and then subsequently the qualitative need for this facility. Issue 1, the acute need, the nature of the need across the East and West Midlands. Last year, the DfT published an update to the earlier Circular 2 of 13. That acknowledges there's a shortage of parking facilities for HGVs, and in some cases this leads to unsafe and informal parking or non-compliance with mandatory breaks or rests. As Mr. Stack highlighted, HGV drivers must not exceed 4.5 hours of driving without taking a 45-minute break. The standard day must be no more than 9 hours, and no more than 56 hours in a week. They are then required to have an uninterrupted 9-hour break. That can be reduced up to 3 times every 2 weeks. It means it's incumbent on drivers to take proper breaks to comply with regulations. This, as well as the general need to take breaks on long distances, gives rise to a need for adequate rest facilities. The extent of the identified need is to be assessed by information from regular updates from the DfT's National Survey on Lorry Parking and Demand Assessments undertaken by National Highways to ensure the appropriate evidence is available on the national situation. That also refers to the formulation of policy responses in order to help in meeting the need. However, it's common ground there's no such allocation for HGVs within the local plan, nor is there any policy that recognises the importance of providing adequate overnight lorry parking facilities, taking into account local shortages. In short, there is no policy which seeks to deal with the need arising in this borough. The NSLP has been through 2 recent iterations, both of which are relevant to the determination of this appeal in 2017 and 2022. The NSLP identified that there was quite clearly a need for lorry parking in many places in and around Rugby as far back as 2017. Notable are the references to the instances of HGV theft hotspots around Rugby, as well as evidence on considerable examples of off-site lorry parking. Similarly, the heat map demonstrates there is a high density of off-site parking in this area of the country. These were matters that the local planning authority would or should have been aware of in drafting the local plan. So too, the then extant NPPF, both 2018 and 2019 versions, provided in similar terms, therein paragraph 107, the formulation contained in paragraph 109 of the 2021 version. Based on the approved categorisation, the NSLP 2022 demonstrated that the utilisation levels across all on-site parking facilities on the SRN is reaching the critical level of 85% across the whole of England in what is typically described as a quieter month. Across the country, whilst the on-site facilities have increased by 5%, the need has still not been addressed. Of regional significance, Table 5.1 of that study indicates that the utilisation rates are in excess of 92% for the East Midlands and 84% for the West Midlands. That amounts to an excess of vehicles of 1191 for East Midlands and 458 for the West Midlands. The site is on the border between the two, and as Mr Weeks agreed, it's necessary to have regard to both in considering the appeal proposal on this site. This is excess vehicles based on 100% capacity. That's not assessing the practical capacity at 85%. There would need to be an increase in that figure of some 15%. As Mr Stack highlights, the shortfall should relate to the vehicles both on and off site. One may compare and contrast that with the approach that Mr Weeks takes, relying upon the immediate response figures as an indicator of need, replicating the exercise undertaken in the 2017 study. Mr Stack agrees with this approach as an indicator of need. First, the immediate response calculation looked at the number of HGVs on site, but discounts those off site. The 85% utilisation is then redistributed to those with capacity. Given the extent of saturation at nearby facilities, it is unrealistic to think that they can accommodate many more trucks either. Further, the redistribution exercise is notably absent from the 2022 surveys. Mr Stack suggests this is because it's inappropriate, and to give a more rounded view on need, the 2022 NSLP plainly had regard to both on-site and the off-site calculation. It's common ground that the 2022 survey does not set specific numerical targets, a point that seems now to be advanced by the Council, but it reports on the situation on the ground in a normative sense. As Mr Weeks fairly accepted, though, it is necessary to meet the needs of the industry to deliver a quantity and quality of service. He accepted this need was a key driver of the policy position nationally. The point that there are not, therefore, numerical targets to incentivise delivery to meet such needs, therefore goes nowhere. The fact is, there is a shortage locally that does give rise to parking in locations that lack proper facilities. That's the policy test. The problem is well reported, well evidenced, and well understood. The need must be met where it arises, and so targets are not necessary. Plainly, across many indicators, the East and West Midlands have an acute shortage of spaces. Turn to issue 2, the need in the Magna Park area. The site is within the Golden Triangle, an area which is the beating heart of the UK logistics development for its accessibility to the north, south, east and west of the country. The concentration of development, combined with its proximity to each area of the country, means that it has a high concentration of trucks. That's particularly the case given its proximity to Magna Park, which is widely regarded as one of Europe's premier logistics developments. For that reason, it's perhaps unsurprising that Mr Weeks accepts there's a need within the Magna Park area. What is perhaps more surprising is that notwithstanding the extent of the development, there are just 2 lorry parks within the local area, neither of which are on Magna Park itself. Both are at capacity, 126% and 94%, with any additional demand accommodated in local laybys and other inappropriate facilities. The PJA study adds a granularity to the general picture of the East and West Midlands. Mr Weeks conceded there was no better evidence before the inquiry and was otherwise accepted. Mr Weeks highlighted that his concerns only related to a minor issue related to school holidays, and the issue of weight could be given, and that issue of weight that could be given in evidence in the planning balance. With respect, that concession represents a clear acceptance of the appellant's evidence on the scale of need in the area. Across the region, there's been an increase in the general number of spaces, but utilisation has also increased from 76% to 83%. Moreover, Mr Stack highlights that there's been a worsening between 2017 and 2022, as demonstrated by the results in the NSLP. Whilst new capacity has come on stream over the past 5 years, the demand has grown at a faster pace. That plainly does not suggest that the need has reduced over time. It's got worse and will continue to deteriorate. That pace of growth has been particularly rapid in this area. This is owing to the continuing high level of investment in building new warehouses and distribution centres in the East Midlands in recent years, including the expansion of Durfton Magna Park. The appeal site is within 15 minutes of both facilities, and Magna Park, indeed, is directly opposite. Moreover, that pattern of growth is expected to continue. The Magna Park expansion is set to increase HGV traffic by 3,652 two-way trips per day, an increase of 92% compared to existing development. That is likely to compound the problem only further. Mr. Weeks' response to this is that there have been several applications for truck stops that have come forward. That includes Magna Park itself, Mere Lane. There are two issues with this. At most, it would provide some 94 overnight spaces, just 6% of the combined regions I think it should be need. That goes down to 80 spaces at the practical capacity levels. Moreover, he confirmed that he had had no engagement with Magna Park about their aspirations for that site. So even if this was consented, it would still be less than 60% of the combined Midlands area need. He also relies upon the land adjacent to Magna Park, which benefits from a hybrid planning consent too. This lacks any basic facilities, such as toilets, shower or cafe, and would be otherwise inappropriate for overnight parking as defined by the rating system in the NSLP. And as Mr. Stack highlights, we can only assume it would have an NSLP rating of less than 1. Turn to issue 3, the qualitative need. Not only is the quantum of service provision inadequate, but the qualitative experience is also lacking. Within the East Midlands region, only 20% and 8% of lorry parks, respectively, achieve a 4 and 5 rating level, respectively. Medium to high-end parking is defined, i.e. the medium to high-end of the NSLP. For the West Midlands, it's 14% and 8% achieving those ratings. Mr. Stack's case is there is an immediate requirement for better quality lorry parking facilities, in addition to increasing the number of spaces. And that was not challenged by Mr. Weeks in cross-examination. There are several other important points to note. First, the high utilisation rates mean there are knock-on implications for drivers who are having to take timed breaks. There's a link between the quantitative need and the qualitative experience, as one of the biggest concerns from drivers is the lack of parking spaces available. HGV's stringent regulatory requirements limits the time that they can drive away from where they need to be to take rests and mandate the period of rest that is compulsory. Facility saturation makes it very difficult to plan ahead as part of the journey. This also has knock-on consequences for route selection, where drivers can go and park, and it becomes a particular issue if multiple facilities are full. This can have consequences for drivers parking on slip roads, curbsides, and in car and bus parking spaces. In an area where a high volume of traffic passes through for the distribution purposes, it's natural for such facilities to be located where they are needed for rest. Second, the majority of current truck stops are inadequate in even delivering what may be described as basic facilities. Table 3.2 of the NSLP describes how on-site parking facilities range. Only 23% of the on-site parking facilities are rated 4 and above and have security features. The majority, 35%, are rated at 3, which includes basic amenities including a toilet, shower, and cafe. That only goes to show how inadequate most facilities are. That substandard service is compounded by the fact that the vast majority of drivers, 79%, reported that the availability of good quality lorry parking, both free and with a charge, had decreased in the last 5 years. 94% were saying that the washing, shower, toilet facilities are not good enough. Similarly, well-maintained toilets and showers, CCTV, security staff, security fencing are cited as 4 of the most important features on an on-site parking facility with a charge. That state of affairs is also unacceptable. Third, these stops only fail to meet the basic needs, not only fail to meet the basic needs of drivers, but also fail to protect the goods they're carrying. The main barriers to using a truck parking facility with a charge are recorded in the 2022 NSLP. Drivers need security, and Mr Weeks did not take issue with that. Those are also issues which the appeal scheme expressly seeks to tackle, including with a Label 5 security level. Fourth, inadequate facilities have knock-on implications for the wider community. The Council have sought to advance the point that the fact that high levels of off-site parking are recorded may not be indicative of capacity saturation on site. They may just indicate that HGV's drivers don't want to pay. That contention does not appear to be borne out by the NSLP. Pick any four letters and perm them. The 2022 study, at Table 5.1, which indicates, in contradistinction to the position in the 2017 survey and Learned Friends cross-examination question to Mr Holmes, that nearly half of drivers prefer to park in non-lorry park situations, that the figure would be less than a third. And Mr Weeks conceded, though, that it may be indicative of other factors, including the poor standard of facilities. Mr Weeks accepted that some people are forced to park off-site as the facilities are not meeting their needs. To suggest it's only an unwillingness to pay would be would be inconsistent with the findings of the NSLP or the LSP and with the aims of national policy. It also has an undesirable knock-on implications, including the inability of police officers to move trucks on in circumstances where there is simply no space to accommodate them. Fifth, the failure to meet the needs of drivers can result in the wider problems for the haulage industry. This is a scheme which has gained the support of the Road Haulage Association, which highlights the importance of maintaining driver availability, and that's particularly important in circumstances where in 2021 there was an acute driver shortage. By contrast, the appeals scheme goes some way to meeting the need. There's no other local competition to the standard of level 5, recognised to be important for its security credentials. Aside from the quantum of parking spaces, it has a facilities building, including a hotel, which will deliver a range of benefits, including space for meaningful rest, showers, toilets, cafe and other facilities, with appropriately high levels of security. A full-time on-site 24-hour security with a manned security office, fencing and CCTV will also be provided. And that level 5 label security rating is a standard to which the appellant is willing to commit by way of condition. So as to conclusions on need, this facility is plainly not too big to meet the needs at this location. Nearby facilities are overutilised. The lack of a numerical target from central government, as might arise, for example, in the residential context, is unnecessary. Whilst the proposal would make a substantial contribution to meeting need, it does not even come close to meeting the needs of the wider East and West Midlands, even taking account of the prospective sites nearby. The suggestion that lay-by parking is free is, I think, is better considered, misguided, in circumstances where there is clear overutilisation, and lorry parking survey and PGA study all point to the need for more facilities and of better quality. As Mr Stack highlighted, the parking of laybys parking in laybys is wholly unsatisfactory. While some drivers may do so out of choice, many will do out of necessity. And he highlighted too that drivers will sometimes sleep with the back doors of the lorry open to indicate there's nothing available to steal. That's inappropriate, and that's a view shared by government. The same story is reflected across many industry groups, from Unite the Union to groups such as Women in Transport and the Road Haulers Association. And those stakeholder groups have routinely raised concerns around the lack of security, lack of parking provision and quality facilities. To put the point shortly, the Council's need case was at best fragile at the start of this inquiry. There is clearly a need. The need is clearly identified and evidenced in this location. Upon the Council's evidence being further interrogated, its need case now looks wholly unjustified. Turn to landscape impacts. There's a high degree of agreement between the landscape experts There's agreement that the Council's case relates to two local plan policies, NE3, SDC1, and the relevant tests in the NPPF. This is not considered to be a valued landscape within the meaning of NPPF paragraph 174 and actually 174A. This is not a designated landscape of any kind. It's not in the green belt, not considered to be in the setting of the green belt either. There was agreement too on landscape value. The landscape is not uniquely distinctive in any way. The tension between the experts on the landscape case appears to be focused on the impacts on landscape character and the visual effects of the scheme, and we take each of those in turn. First of all, the landscape character areas. The first issue that emerged during the roundtable discussion was the relevance of the A5's dividing line between the landscape character areas. First, the Council rely upon the A5 as a key boundary line between the two LCAs. It considers it to be a defensible boundary that must not be breached. Whilst it's acknowledged there are two different LCAs, that's unsurprising, given the LCAs are in two different administrative areas, different local authorities responsible for their authorship. The division of LCAs in this way, the east and west of the A5, has a high degree of artificiality and does not provide an adequate basis to justify refusing permission for the refusal. Second, the LCA in which the site is located is extensive in geographical extent, within which there is inevitable variation in landscape character. As Mr. Ingham describes it, it's a transitional landscape. It does not have any perceptual landscape qualities in relation to tranquility or wildness, nor does it form a recreation function. Third, and what is more striking, is the landscape surrounding the site has evolved considerably since the landscape assessment of the Borough of Rugby Sensitivity and Conditions Study 2006 was published. This has included the development and then expansion of Magna Park on the opposite side of the road, which has clearly had a material, even if indirect, effect on the character and landscape west of the A5. Fourth, the methodology for those LCAs too is now considerably dated and is not based on best practice. The sensitivity judgments contained therein should be given little weight, so by you. Whilst the LCA is plainly relevant, it should be treated with those important caveats. Issue 2, the rural nature of the appeal site. Much was made by Mr. Wakefield of the rural and open nature of the appeal site. However, its context is demonstrably influential in an extensive range of ways. The context presently comprises extremely large utilitarian storage buildings set behind landscape buffers. The movement of HGVs are very much a typical component of the views from the A5 and Lutterworth Road on the approach to the Cross in Hand roundabout. It is perhaps unsurprising that although Mr. Ingham does not consider the form of the proposed development in that context, does not consider the form of the development to be incongruous, it is not the case the logistics activity is simply hidden behind a buffer, screen planting on the eastern side of the A5. It is omnipresent and dominates the character of the fields which surround the roundabout, including those within the appeal site itself. The existing roads, the HGVs, the lighting and the extent of development around are plainly relevant factors. In this regard, Mr. Ingham concluded that the site would not be a prominent development that would be perceived as a major encroachment into the countryside. The views would be limited to relatively short sections of the A5 and Lutterworth Road, approaching the Cross in Hand roundabout, as well as glimpses to the west. The effects would be limited and localised. The montages and photographs provided to the inquiry confirm that. Where the development is visible in distant views from footpaths to the west of the A5, the proposed development would be seen against the backdrop of Magna Park and would be indistinguishable from it. Moreover, there are a number of contradictions evident within Mr. Wakefield's own evidence. Paragraph 5.9 of his proof of evidence, Mr. Wakefield suggests that the sense of remoteness would be lost. However, inherent within his evidence is the acceptance that the large area covered by Magna Park, in combination with the large scale of the units within, has resulted in it becoming dominant within the landscape when viewed from the surrounding landscape. That does not suggest that this is a remote landscape or one that exemplifies that character. The Council seeks to take a point about the difference between the various consultancies, drawn conclusions between medium medium-low sensitivity to change. Whilst those judgments are broadly similar, the lowering of the sensitivity was first indicated in the Pegasus LVIA. These photographic viewpoints presented, those photographic viewpoints presented in the original ADAS LVA are based upon photography predating the expansion of Magna Park, immediately adjacent to the site. They also predate the changes made to the application. The Pegasus LVIA provides a more detailed, accurate baseline and provides a reasonable visual representation of the proposed development and should be the primary reference visualizations. Issue 3, the visual effect of the scheme. The visual effects of the scheme were scrutinised in the roundtable discussion. The photographic viewpoints presented by Mr. Wakefield's evidence are all focused on the site and do not show the full 360-degree context of the view, or in many cases the primary direction of the view, i.e. along the road. At certain viewpoints, Magna Park is dominant in the view, albeit slightly out of shot in the views presented. In paragraph 734 of his evidence, Mr. Wakefield summarises the findings of his own visual appraisal. It's concluded in respect of viewpoints 1, 2, 3, 4, 5, 22, 23, 24, 25, and 26, there will be a major adverse impact. But all other viewpoints, the effects will be no greater than minor adverse. So I would just add, by way of interpolation, whether it's Mr. Wakefield's evidence or the other material that you have before you, you will have the opportunity to view that next Wednesday. Issue 4, height, massing and uses. In addition, what's said against the scheme is that there are issues with height and massing, that not all the uses are necessary. It's important to remember the scheme is governed by a parameter plan. By his own assessment, Mr. Wakefield has concluded that significant visual effects will be limited to a short section of the A5 and Lutterworth Road. All Mr. Wakefield's viewpoints lie on the A5 or Lutterworth Road immediately adjacent to the site boundary. It's perhaps to be implied, therefore, that it can be no greater than a minor visual effect, owing to his own terminology and methodology. He also summarises his conclusions regarding visual effects in year 15 following establishment of mitigation, and he concludes that the effects will be moderate or moderate minor at these same viewpoints. The primary visual receptors of the scheme, i.e. the users of the A5 and the Lutterworth Road, will be of low sensitivity rather than the medium assumed by Mr. Wakefield. Whilst the Glivia 3 suggests motorists are usually of an intermediate sensitivity, there is flexibility in this statement, and the preceding paragraph in the guidance notes the context is important. The dominant visual presence of Magna Park on the approach to the roundabout in this instance is relevant, and we would say lowers the sensitivity of the locality. Turn to other matters. The Council have doubted whether the proposed development is developable on the land that's available, and whether the site is capable of accommodating the uses set out. That contention is rejected. As Mr. Holmes reiterated, the scheme is capable of delivery and has been subject to an illustrative version of the scheme. Mr. Weeks said he had not taken issue with density, but simply the point there was a question about whether the site was capable of accommodating all the uses in the manner which had been set out. That can be dealt with simply. First, the application is only made in outline. Beyond the parameter plan, the mix of uses, design and layout are all matters which are within the control of the Council at the reserved matter stage. It's not a matter, sir, for you to have to decide at this stage. Secondly, it's within the Council's gift to control all the matters which Mr. Weeks complains of, including layout and design, and that Mr. Weeks fairly accepted in cross-examination. The Council takes the point about the area of space available to deliver all the uses on the site. The proving plan shows that the relevant components of the site that can be accommodated. However, notwithstanding Mr. Weeks' position, Mr. Holmes confirmed there will be sufficient areas within the site to accommodate a delivery bay and the petrol filling station, and the scheme is intended to provide flexibility. Secondly, with regard to the petrol filling station, Mr. Holmes was right to suggest this was an entirely reasonable ancillary feature to be co-located with the HGV park. It's to serve the needs of other logistics vehicles and traffic. The Lim truck stop can include such a facility, and Mr. Holmes was mindful too of the fact the facility could be turned over to electric vehicles in the fullness of time when the sale of petrol and diesel vehicles are banned. Much has been made of the shop too. The provision of that facility has been identified of a standard deemed to be at least quite important to the lorry parking survey. It's envisaged the offering here will be comparable to that offered at the Lymm truck stop. The creche is a minor addition too. It was suggested to be provided on the basis. It is suggested to be provided on the basis of the knowledge of the promoter, whose experience of working within Magna Park. It would be a secure facility to help address the need. However, in any event, if the council now take a different view, there's only a small part of the offering and the floor space in the facilities building which could be omitted, sir, if you considered as necessary. It doesn't go to the heart of the issue on whether or not consent should be granted on the outline scheme. Long-term lorry parking facilities will require as an essential attribute the charging for battery electric lorries. And this low carbon outcome needs to be considered for electric lorries to play their part in local and national climate change targets.
So take your time, Mr. Gately.
Filled up this time, sir. If only there were Wetherspoons nearby. Thank you very much. Long-term lorry parking facilities will require as an essential attribute the charging for battery electric lorries, and this low carbon outcome needs to be considered for electric lorries to pay their part in local and national climate change targets. Current provisions do not meet the needs of drivers. Such criticism cannot be levelled at this scheme, which may have the impact of improving provision elsewhere. Third parties have raised a number of concerns around existing issues that occur primarily through the village of Pailton and surrounding rural roads that they consider will be exacerbated by the proposed development. These issues fall mainly into three categories, which relate to the speed of all vehicles, the volume of HGVs, and the suitability of the road to accommodate HGVs. Local residents are concerned that the proposed development will result in an increase in the volume of all types of vehicles passing through Pailton, leading to an increase in safety concerns. They are primarily concerned that the proposed development will lead to an increase in HGVs through the village, which is considered by residents to be an unsuitable route for HGVs due to conflicts with pedestrians, including school children, and the proximity of properties to the road, resulting in air quality, noise and vibration concerns. Lutterworth Road is a B classified road, B4027, which forms part of the county's road network, primarily functioning to carry all types of traffic. As a result, there are no vehicle restrictions. However, the road is not more convenient than other high-grade routes such as the A5, unless they are travelling to a destination within the rural area, or if there are high levels of congestion on the SRN. Reports made of HGVs using Montillo Lane. However, this does have a 7.5-tonne weight restriction and therefore is an enforcement issue for the Highway Authority to consider. The traffic surveys contained in Appendix 7 of the TA demonstrate that on the day of the survey there were very few HGV movements using Lutterworth Road on the approach to the Crossing Hand roundabout. There are also no known congestion issues on this day along the A5 or wider SRN. The proposed development is aimed at providing roadside facilities to passing traffic with the potential for a small volume of traffic to divert from other primary HGV routes. These effects have been modelled using the Highway Authority's strategic rural area model to assess the specific concerns over the additional HGV traffic passing through Pailton. The results, as discussed in section 7.6 of the TA, clearly demonstrates the proposals are not expected to lead to an increase in HGVs through the village of Pailton. Whilst it's acknowledged the concerns around HGV use along Lutterworth Road at present, these proposals are not predicted to exacerbate those problems. Turn to the planning policies and balance. The reason for refusal lists only two policies, STC1 and NE3. Council fairly accepted that it is those policies and only part of STC1 with which this issue is taken, and proposed development is expected to be in conformity in all other material ways. Policy NE3 relates to landscape protection and enhancement. It's permissive rather than a restrictive policy, means that new development which positively contributes to the landscape will be permitted. It's evident that landscaping has been assessed through the LVA and LVIA. Plainly, through the revised scheme, it's evident that landscaping has been significantly increased. For instance, including from a 6 metre to 25 metre buffer. There is no need, as Mr. Weeks suggests, to retain existing features at all costs. There is no policy support for that position either. In sum, there will be an addition of landscape features on which there is currently an agricultural field. Mr. Weeks' approach that you can't enhance if you are replacing it is, with respect, at odds with many well understood principles of landscape design. He was put in cross-examination to Mr. Holmes that he had not taken account of harms in the planning balance in respect of landscape and countryside impact. That's not correct. Plainly, he had taken account of harms. In his proof of evidence, he defers to the evidence of Mr. Ingham. Mr. Ingham had concluded there was compliance with the multifaceted criteria contained within NE3. There was no breach of any one of the bullet points contained in that policy. Plainly, there was no harm against the language of the policy. Mr. Holmes was right, therefore, to consider there was no harm to be weighed in the planning balance. That said, he had specifically considered the issue in context of the approach to balance, as set out in paragraphs 614 and 621 of his evidence. Policy SDC1 requires that the development proposals demonstrates high quality, inclusive and sustainable design. Matters pertaining to sustainable design are not points which are taken by the Council. Those issues pale into insignificance, given that this is an outline scheme. The local plan was adopted in June 2019. This postdated the last iteration of the NPPF and was also subsequent to the National Lorry Parking Survey from 2017. The local plan does not take account of either of those two critical documents. Planning policies and decisions should recognise the importance of providing adequate overnight lorry parking facilities, taking into account local shortages to reduce the risk of parking in locations that lack proper facilities or could cause a nuisance. Manifestly, the local plan does not. The need case has been extensively covered above. The local plan through policy GP2 allows for such development where it requires a countryside location in accordance with national policy. In the absence of any allocation within the local plan for lorry parking facilities in the borough or other policy provision, the requirement stipulated in the circular that signed HGV facilities cannot be situated where HGVs are required to travel through residential areas, plainly the appeal site is an appropriate location in this case. Mr. Ingham assessed the proposal was in accordance with the relevant policy NE3, so in that sense there was no landscape harm, albeit as explored in Mr. Holmes' re-examination, harm's not the relevant test. The development can properly be regarded as being in accordance with the development plan and benefits from the statutory presumption that the planning permission should be granted. As to the tilted balance, paragraph 3 of the NPPF requires the framework to be read as a whole. It's inappropriate, therefore, to seek to dislocate paragraph 174B relating to the countryside from paragraph 109 and the need for lorry parking facilities. There are no policies in the local plan that deal with lorry parking. That's common ground. In that instance, the omission of the relevant policy relating to lorry parking qualifies in the circumstances of this case the accord with the NPPF of the development plan policy cited. Properly interpreted, the policies which are most important for the determination are out of date in this case because of that omission. It then follows there would need to be significant and demonstrable adverse impacts that outweigh the benefits when assessed against those policies in the framework taken as a whole, reference then to paragraph 3 therein. It is not understood the Council's case that there are significant and demonstrable reasons that outweighs the benefit. It necessarily follows that planning permission should be granted. The alternative case put by Mr. Weeks is that there are relevant policies, most notably in the form of that countryside related policy, GP2. He says there are a lack of policies for lots of different uses. Imbued in policy GP2, however, is there will be circumstances where development may require a countryside location, as allowed for in national policy. What those policies don't do is to recognise the importance of adequate overnight lorry parking facilities taking into account local shortages. Those policies that we've referred to earlier do not concern themselves with reducing the risk of parking in locations that lack facilities, proper facilities, or that could cause a nuisance, as paragraph 109 of the NPPF does. It's clear the planning decision should recognise the importance of providing those adequate lorry parking facilities, and in that regard the policy is out of date. I think you can lose the 2, please, if you would. Whether or not a policy is out of date means that it must be by reference to their consistency with the NPPF. Mr. Weeks says the countryside policies are consistent with the NPPF, but that cannot be the case in circumstances where the policy, that policy nor any other, deals with the provision for lorry parking in an affirmative manner. The plan does not say what to do with the HGV issue. Accordingly, the plan is out of date. And again, for that reason, delete the word to, the tilted balance is engaged, and planning permission ought to be granted. But even if a different approach would be taken and a flat balance applied, the considerable and significant weight attributable to the need case in this instance would outweigh any identified conflict with, albeit limited range of alleged conflicting policies contained within the development plan. So with respect upon any basis, planning permission ought to be granted, and for all the reasons set out above, sir, you are invited to allow the appeal.
Okay, thank you. Right, so I think we're at a point of closure at the inquiry, unless either party's got anything else to say, add.
Nothing else from us. We're going to, as you directed, deal with the issue in respect of conditions as a downstream matter, and I understand the SIL statement will similarly be dealt with in that way.
That's been received.
That's been received. I do beg
Yes,
your pardon.
so thanks to Mr. Green for that. Yeah. Okay. Right. Well, I hereby close the inquiry, and thank you all for your participation, and wish you all safe journeys home. So thank you very much. Inquiry's closed.
Thank you, sir.